Court is now in session. It is Monday morning, April the 12th, 9 o'clock a.m., and the Kerr County Commissioners Court is now in session. We have a rather long docket today, so we'll try to be efficient. I'm trying to remember who has the prayer and pledge this morning.
I think I did it last time, I believe.
I did not last time. Commissioner, let's do it last time.
Harris.
I did it last time, so sorry.
Okay.
Well, would please stand for the prayer and pledge.
Lord, thank you for the beautiful day you provided us and all that you provide for us each and every day. We want to thank you for our many blessings, and please watch over our first responders as you always do. Thank you for bringing Harley back to us and getting him back in good health, and amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. As always, let me remind you about your cell phones. If you would at least put them to vibrate so that they don't go off and interrupt the court proceeding. Next is our public input. This is the opportunity where the public has to come address the court and tell us what you would like for us to hear. It is input from the public. It is not output from the court. So we don't get to respond, but we get to listen. Is there anyone who would like to address the court? And I remind you that for those of you that want to call in, the number is 830-792-6161. And that rings on a cell phone that is at the court coordinator's desk, and she will give us your telephone number, and we will call you off of the mic that we have here at the court at the bench. So if anyone would like to address the court, this is your opportunity. And this is on an item that is not on the agenda. If it is on the agenda, we ask that you wait until that agenda item is called. Any input? Well, in case somebody calls, why don't we go ahead and move on with Commissioner's comments. And let's start in reverse today. Kind of let Mr. Harris go first.
Okay.
Precinct 4.
We need a little rain. We still have the burn ban off on Precinct 4, but we could sure use a shot of rain. Looks like we might have a shot at it this week, and we're hopeful for that. And that's about all I got right now.
Good. 3.
I don't believe I have anything. There's a lot of stuff on the agenda I'll be talking about.
Good. 2.
Yes, Judge, thank you. There was a information meeting held by TCEQ on West Texas Aggregate Quarry last week. Lasted an hour and a half. TCEQ did a very good job of listening to everybody, explaining what they could and couldn't do. There was a lot of participation from neighbors from the quarry. One of the big concerns was noise. Nothing TCEQ can do about that. The other one was proximity to some of the residents to the operating equipment. TCEQ agreed to come out and take a look at that. TCEQ was very proactive in this, and this meeting was called by Andy Murr, so it worked out well. And Kelly Early was on the conference call for that. It was all held virtually. So the other thing was silt in the air. A lot of evidence from that. So TCEQ registered on both of those, gave the phone numbers of the right contacts for people to call. So I think it was very positive. I felt very positive about it. So things are working. So that's all I have.
Very good. Precinct 1, welcome back.
Thank you. I want to thank the board and everybody that prayed for me, because he heard and carried me through it. And remind all the kids, always put safety first, kids. Don't do what Uncle Harley did. And I'm glad to be back. Thank you.
Good. Okay, let's move on to the consideration agenda. Item 1.1, consider, discuss, and take appropriate action regarding the update, facility use, and other matters related to the severe winter weather disaster. Bev Thomas.
Morning, Judge. Morning, Commissioners. Welcome back, Harley.
Thanks, sir.
At this point, we've still been submitting the ISTAT and the information from the PSTAT is being submitted through another database. Basically, we're uploading all our documents into TDM and FEMA for their perusal. The ISTAT information and the PSTAT data all needs to be completed by April the 19th, because on April the 20th, all of that is going to be submitted to FEMA. at this point, we're still trying to get some more information sent for the individual assistance declaration. The survey itself, so far we've had 545 total submissions. 3 are destroyed. Major is 169, minor damage 119, affected 57, minimal damage 197. So about a week and a half ago, I got an email from a representative at TDM that gave us 30 homes. 19 of those needed to either have, they met the FEMA criteria. They're either no insurance, underinsured, major or destroyed. And so 19 of them, they either left off the address or they didn't submit pictures, which means they probably did the survey over the phone on the toll-free number. So I've emailed, called multiple times, all of those individuals. Several of them have responded, several of them have already redone the surveys and completed them. Last Thursday, the issue that TDM asked me about was the 3 that we were showing as destroyed. When you look at the individual assistance survey, the data there, so those individuals showed destroyed but livable, which is kind of not. It doesn't.
Oxymoron.
It depends on your standard.
It depends. I guess so. So one of those destroys turned out they were not. I called them personally, and they were actually from Live Oak County. So when somebody when they did the survey online, whoever took their information down, put something in there wrong, and somebody from George West wound up in Kerr County's data. The other destroyed we had was actually an outbuilding, and that's not really going to count as far as it's usually the main home is the one that they're looking at. And the other one, the third major one that I called about, she refused to submit photographs until Kerr County has been accepted into the individual assistance. And I couldn't convince her of the fact that we're not going to get individual assistance if you don't submit those photographs. So, and she was adamant about it. So at this point, it's probably going to be up to our the major damage ones that are listed in there. There were 30 total. So 11 met the criteria that had photos and address and everything. So as those individual assistance surveys have been redone by the folks that were cooperative, all that data is being forwarded on to FEMA. So I'm hoping sometime within the next 2 weeks we'll find out whether or not we're included in individual assistance.
Okay.
That's it for right now. I mean, the auditor's office is submitting everything into the database, what do they call it, the NAS or something like that. And so we're just waiting.
Well, Doug, let me ask you, we're getting ready to, the next item on the agenda is to talk about this state of disaster order that we entered back in February when the storm was going. What are your thoughts? Should we continue to extend that order of disaster or state of disaster order, or do we go ahead and terminate it?
I would go ahead and terminate it. I think at this point, the disaster's over. We're submitting our documentation. Most everybody that I have not heard of anybody that has not had their home repaired, but I'm sure there are a few out there. But at this point, it's still up to their insurance and stuff like that. But at this point, I think we can not extend the disaster order.
You don't think it has any bearing on it going forward?
No.
Okay. As far as anybody getting.
I don't know. It won't have any bearing.
Okay.
Very good. Anything for Doug Thomas?
I wanted to just state that a lot of people early on seemed to be critical that this was moving slow. You can see why. It's obvious to see why. It wasn't Doug's fault. It wasn't our emergency management. It wasn't even FEMA. It was our participation.
Well, we've still got till April 19th. The date, the final date is April 20th. That's when TDM submits everything to FEMA, both from the public assistance side and from the individual assistance side. But some of our individual assistance stuff is already going up to the FEMA to try and get us into the individual assistance declaration. But yeah, you can drag the horse to water, but you can't make it drink.
So, for those in the public that are watching, anyone that has a claim, now's the time to get your paperwork.
If you haven't done a survey, do it anyway. If you had damage.
Very good. Thank you.
Yes, sir.
Next item on the agenda is 1.2, consider, discuss, and take appropriate action regarding the local and state of disaster due to severe winter weather order that was signed by me on February the 22nd and extended until terminated by order of the Commissioners Court on February 23. I think that's the reason I asked Doug, because I knew this is what was coming up next on the agenda. Any comment or questions anybody wants to ask about that before we...
Judge, I make a motion that we terminate the emergency declaration signed by you on February 22nd, 2021.
Second. Go ahead.
Okay, motion's been made by Commissioner Letts, seconded by Commissioner Ballou to terminate the state of disaster order that we entered back in February for the storm. Is there any other discussion?
As long as it doesn't have any bearing on our citizens getting the help, then there's no need for it.
Well, that's why I asked Doug while he was here.
You bet.
So, okay, with that, those in favor, raise your hand. Unanimous, 5-0. Moving on to 1.3, I saw Mr. Melton out in the hallway just a minute ago. Consider, discuss, and take appropriate action to approve a proclamation designating May 6, 2021 as National Day of Prayer, and approve the request to use the courthouse grounds for an event that day. Matt Nelson.
Good morning.
Good morning.
I'm Matt Melton. I'm a chaplain over at Peterson Health, but today I'm here with the to represent the Kerr Ministerial Alliance, and we're requesting use of the flagpole area in the front yard May the 6th, Thursday, for the National Day of Prayer. And there's a proclamation. If you would be willing to sign that, we would appreciate that. Last year, David Danielson was here with the same request. I think we've been doing this many years.
Question on the proclamation.
Yes, sir.
It says America was founded upon the principles of Christian faith and freedom. Was it not Judeo-Christian as opposed to just Christian?
That's a good point. We could add that on there.
Yeah. And I'm just asking the question. I think that's my understanding.
Yeah.
So I think that change would be appropriate if we could do that.
All
Okay.
right, thank you.
Okay. Other than that, looks good to me.
I move for approval.
Second.
A motion's been made by Commissioner Harris, seconded by Commissioner Moser, to approve the proclamation designating May 6, 2021 as National Day of Prayer, and approving the request to use the courthouse grounds for an event that day. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0.
And change that proclamation.
Correct.
Thank you.
Thank you.
Appreciate it.
That wasn't so hard.
No, sir.
You did great.
Item 1.4, consider, discuss, and take appropriate action to adopt a proclamation proclaiming April 25, 2021 to May 2nd, 2021 as Soil and Water Stewardship Week. Denise Griffin. We have Denise Griffin out there. Sheriff, you check.
Denise Griffin. No, sir, Judge.
Okay. Well, we have a copy of the proclamation in our packet for today's agenda. Is there any discussion about this item?
I would just, if she was here, I was going to ask her about what might be done to educate the public more on conservation of water.
Are they watching upstairs? Do you know?
I know the central jury room upstairs, courtroom upstairs is for the overflow. I don't know if anybody's up there or not.
Well, that was going to be my question. There's a lot of, we're getting more and more into drought conditions, and I think there's a lot of, probably educating the public more on conservation of water would be appropriate. Yeah.
They do a good job of that. I've seen several of the things they've done with the schools and what have you, as far as getting vegetation growing immediately to keep erosion down and stuff like that. And then, as you point out, as well as conservation. So they do a good job.
Yeah.
In view of all that, I'm going to move for approval.
Second.
Okay, motion's been made by Commissioner Harris and seconded by Commissioner Letts to approve a proclamation proclaiming April 25 through May the 2nd of this year as Soil and Water Stewardship Week. Is there any discussion?
Yeah, the only reason I brought that up, Don, is is you still see a lot of people pumping water into vanity ponds, you know, not for cattle, not for
Right.
anything, except for just evaporation
Right.
into the appearance. So,
I agree.
and a lot of people just don't understand the criticality of the aquifer and the lack of rainfall. So anything that they could do to enhance that, that'd be good.
Yeah.
Okay.
Okay, those in favor, raise your hand. Unanimous, 5-0.
It's empty.
We approved it anyway, thank you, Sheriff. Let's move on to item 1.5, consider, discuss, and take appropriate action regarding the hog abatement interlocal cooperation amendment number 1 between Kerr County and the UGRA. Commissioner Harris.
Yes, this is an ongoing agreement we have with UGRA as far as the feral hog program, abatement program. What we're doing here, and they've already approved it, they're going to be using some of their funds for this, $600 for 6 months subscription for our traps, to where people can activate them by their cell phone. You know, they can see, okay, the whole sounder's in the trap, and they can click and trap them. And we have a couple traps like that that we loan out. And so, but the subscription with AT&T is like $600 for half a year, and so that's what it's about.
So how many traps like that?
We
do
have 2.
2.
Yes.
Okay.
Yeah.
The
So
trick is you have to be in cell phone service area.
exactly,
Yeah.
and that can be a problem in some areas.
Yeah, might be an issue, but they work great.
Yeah.
Is the total just $600?
For the 6 months.
Yeah, that's the amendment to our
For
total agreement.
Okay.
So
We're paying for half of it.
That's
they're
the cell
paying for
phone.
this whole subscription.
Okay, good.
The 600 is to cover the cell phone monitoring service.
Activation,
Is that, and they
activation.
said 2 traps,
Yeah.
that's 600 per trap?
No.
Or is it just $600? I'm
Just
guessing it's-
$600.
Okay, so we're paying half,
Mhm.
okay.
All right, I move for approval.
Second.
Motion been made by Commissioner Harris and seconded by Commissioner Moser to approve the amendment number 1 to the hog abatement interlocal cooperation agreement with UGRA. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0. Item 1.6, consider, discuss, and take appropriate action to accept a donation of a park bench at Flat Rock Park. Mia T.
I don't believe Mia's here, Judge, but I'll speak for her. Mia would like to donate a bench similar to that we have in Flat Rock Park right now in memory of her mother, okay? And so it'll be the same type that's there, the location to be determined by Shane and herself. So I would move for approval, acceptance of a bench consistent or contingent on approval by Shane for the bench and for the setting of the bench
Second.
location.
That would actually be the maintenance department.
Yes, the maintenance part, correct, thanks.
Okay, the motion's been made by Commissioner Moser and approved, seconded by Commissioner Harris to approve the placement of a park bench at Flat Rock Park, subject to approval by the maintenance department. Is there any discussion? Those in favor, raise your hand. Unanimous, 5-0. Item 1.7, consider, discuss, and take appropriate action regarding the First Amendment to the Professional Services Agreement between Kerr County and Peter Lewis Architect and Associates. Michelle.
Good morning. The original contract was entered into on the 23rd of July in 2018. It had a dollar amount for the total of 3 years not to exceed $50,000. We're asking that be changed to $85,000.
So that's a 70% increase. I'm
This
listening.
has to do with the Community Improvement Committee, and so
Capital
getting that
Improvement
plan together.
I see, okay, so that's the primary reason. for the-
Yes.
Okay, gotcha.
Does
Thank
this
you.
include the look at the courthouse for the use of space in the courthouse?
Yes.
Yes.
Part of the
So it's part of
expenses
that.
through there during
That
that
started
time.
off as a much smaller thing,
Mm-hmm.
typical government fashion, it expanded.
Mushroom.
Well, what this includes, it goes back to 2018. And the initial scope of his engagement was to come in and give us a recommendation on how to remodel this courthouse and rearrange some offices. We took a look at that after he did a lot of work on that and decided that we needed more than that. And so we started off then looking at potential capital improvements. We formed the committee. He's worked closely with the committee, attended all the, I think he's attended nearly every one of the CIP meetings, and has been very actively participating on our behalf with the ADA improvements we're doing at 550 Earl Garrett, over various uses of the 600 Earl Garrett building that we're talking about moving to the tax office. He's been very active with the animal control facility out on the 16 acres that we bought off of Spur 100. Looked at the work with us when we were talking about possibly doing something where the maintenance building is now, and also has been very helpful in helping us determine the fair market value of that property should we ultimately decide to put it on the market. So his assistance has been absolutely invaluable to what we've done on capital improvements.
He also did
Well,
a lot of
actually, there's a
work.
value on it.
Yes, there is.
We're gonna talk about that.
Also, he did a lot of work at the animal shelter on
Yes.
redesigning it to, if we stayed there.
It
So,
covers a lot of different things
Right.
that he's been working on.
Right.
It's been-
okay,
And
good
it
enough.
includes the, the show barn out of the ag barn.
Big increase, but a lot of additional work. Got it.
He's been a very, very important member of the team, and he's been very faithful and supportive of the
Good.
county.
Okay.
I move for approval.
Second.
The motion's been made by Commissioner Letts and seconded by Commissioner Baloo to approve the amendment to the professional services agreement between Kerr County and Peter Lewis Architect and Associates to $85,000. Is there any other discussion?
I would say that this is not just professional services, this is really an investment in the future of the county, so that's the way I view it, and so you have to, that's what it's turned into in my mind. You have to start at the ground floor, can we do this? No, what else do we do? And it's grown. I don't want people to think it's just an expansion and mission creep. It was necessary.
Necessarily, it's been preliminary design and cost analysis of every step of the way, looking at everything.
Anything else? Those in favor, raise your hand. Unanimous, 5-0. Thank you. Item 1.8, consider, discuss, and take appropriate action to establish maintenance petty cash fund of $100 for the Texas Local Government Code, Section 130.0909.
Yes, the local government code, section 130.909 states the Commissioners Court of Accounting may set aside from the general fund of the county for the establishment of a petty cash fund for any department head approved by Commissioners Court, an amount approved by Commissioners Court. The petty cash fund must be established under a system provided and installed by the county auditor. The county treasurer and the county auditor are requesting a maintenance petty cash fund of $100 to be maintained in the office of the county treasurer only for the purposes of car washes and inspection for county vehicles. Maintenance staff will request cash by completing the sign-out sheet. Change will be returned to the treasurer's office along with an invoice or a receipt for the purchase.
This is certainly not a large amount of money, but why now? We hadn't been washing the cars before now, or what?
We've been using it, we're making it formal with y'all's
Okay,
vote.
I see. I move for approval.
Second.
Okay, motion's been made by Commissioner Moser, seconded by Commissioner Harris to approve the petty cash fund of $100 for the maintenance department. Is there any other discussion?
Where do you go to pay the car washing cash? Is this quarters?
Most of
Because
it's
where I
quarters.
go, it takes quarters.
I don't know.
They'll take $5 bills also. No, they won't.
Okay, they all take cash?
Not all, but some do, no.
I think they go to the car wash over by Stripes and Del Norte Restaurant, that drive-through. I think that's where they go.
Okay.
Okay. Any other discussion? And those in favor, raise your hand. Unanimous, 5-0. Item 1.9, consider, discuss, and take appropriate action to approve budget calendar for FY 2021-2022. Is Jane going to do that?
There's just stand there.
Yeah, you bet.
Mr. Robles, budget calendar.
Yes, sir. Should I have a copy of it? We checked with the judge's schedule to see if the dates worked. It's very similar to the one last year, just coordinated about a day or two to accompany the Monday and possibly Wednesday meetings.
About the same number of workshops and all as
Yes,
we
sir.
have?
Yes, sir. And again, we're working off of the no new tax increase rate.
I move for approval.
Second.
Motion's been made by Commissioner Moser, seconded by Commissioner Letts to approve the budget calendar as presented for FY 2021-22. Any other comments or observations? Those in favor, raise your hand. Unanimous.
Good job, James.
1.10, consider, discuss, and take appropriate action to declare various IT equipment as surplus. Mr. Robles.
We have quite a long list here. This is scanners, computers, printers. And, I think those are all going to be sent for salvage or recycling.
Obsolete.
Yes, sir.
Is that what they do? They just recycle them?
I believe so, yeah.
Yeah.
They take out the hard drives and clean it in the hard drives.
Okay.
I move for approval.
Second.
Motion's been made by Commissioner Harris, seconded by Commissioner Letts to approve the IT equipment listed on the surplus. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0. Item 1.11, consider, discuss, and take appropriate action to ratify and confirm Kerr County pro-rata distribution of proceeds from the Tobacco Settlement Permanent Trust Fund. Mr. Robles.
Yes, this is a program we've done for many years, well over a dozen. This is just requesting a portion of our expenses to be reimbursed by the state. This money will go into Fund 50 at Indigent Defense Services. We get somewhere around $30,000 to $40,000 a year, depending on our expenses and what the state allocates us.
I move for approval.
Why does it go to that particular fund as opposed to?
I think we can only use it for specific reasons.
I see.
That's the most beneficial one. for
Okay,
us.
gotcha. Okay.
Should this not be to ratify, since it's already been signed?
That's what it says, to ratify. and
Oh, I'm
confirm.
sorry. I think it should approve.
You're right. But I need a second for Commissioner Harris's motion.
Correct.
Okay. So the motion's been made by Commissioner Harris and seconded by Commissioner Blue to ratify and confirm our pro-rata distribution of proceeds from the Tobacco Settlement Permanent Trust Fund. Any other discussion? Okay, those in favor, raise your hand. Unanimous, 5-0. Now we're at an unusual juncture in the agenda. This doesn't happen often, but we are actually ahead of schedule. And you'll notice that we have items 1.12 through 1.22, those 10 items, or 11 items, are all timed items. And we cannot consider those before 10 o'clock. And it is about 9:30. I don't think we need to break just yet for a break. We've moved pretty quickly. So let's move on over to the untimed items. If you go down to item 1.23 on your agenda. This is to consider, discuss, and take appropriate...
That's a timed item, Judge.
1.23?
23.
20, isn't it? Well, I've got the previous version. Sorry about that.
Okay.
Go.
1.23, consider, discuss, and take appropriate action to approve the First Amendment to the Interlocal Cooperation Agreement of Kerr County and Kendall County, WCID number 1. Commissioner Letts.
Yes, this is something we've talked about a couple times about updating the policy on the interlocal agreement with WCID number 1. And both of the changes I'm recommending are pretty minor. The one, when we read through it, at the time when we executed the agreement, Tetra Tech was just listed as the engineer of the project. So the reason 1.15 is to define project engineer, which says it shall be Tetra Tech or other engineering firm registered in the state of Texas as designated by the Commissioners Court. And that is to really to go into if in the future some other entity or some entity wants to tie into the system, it'll be up to the court as to who the project engineer for that additional work is. It may not be Tetra Tech. Likely it would not be Tetra Tech. Likely it would be the developer or whatever. That would be the project engineer, but Tetra Tech would sign off on it. or we would designate them to sign off on.
Now, can somebody else just become part of it, or does the agreement have to be completely revamped?
No, this is just an amendment. The agreement, if we change a whole lot of it, it's got to go back to the Water Development Board. This is
Yeah, right.
part of our agreement, so we can't really go in there. These are pretty minor changes. So that one is just on project engineers. If something new work is proposed, we designate who the engineer for that portion of the project would be. This is after it's been accepted. The second change is additional construction. We never really, the agreement the way it's written right now gives full operation control to the WCID. We have visited, we being Charlie and myself, I think, I'm not sure if Commissioner Moser was present or not, with the WCID. And it's basically saying things that are done to the system after it's been accepted, a portion of it's been accepted, both WCID and Kerr County have to approve of that. Reason for that is they really are the monitor of capacity. We've had some numbers we've talked about, you know, we've used the word about 900 connections are possible, several hundred more. That's really not accurate. There's not a specific number. It depends on where you are, how you are from the system. So this says that they handle that part of it. That's their job, and they have to have approval of that. But we have to approve it because we have an ownership interest in the system. I will also note that there's some language in there about we do not have an ownership interest in the entire system, wastewater system that has been built. We only have an ownership interest in the portion in Kerr County. And we did that originally mainly because of the sewer plant. They didn't want us to have our finger in the sewer plant, and we didn't want our fingers in that sewer plant. So this covers everything in Kerr County only. And the language under the additional construction follows very closely to how change orders are done. That's where that language we had basically expanded the change order into that our new provision.
So does this mean it's kind of a handoff at the county line?
Right.
If there was any trouble, WCID oversees that and
Right. Yeah.
smooths things out.
Yeah, if it's in, and we didn't want to own something that was already there, about the portion of the ownership in Kendall County. We just didn't want to own anything in Kendall County.
This is primarily about changes.
Yeah.
In other words, if the system just were to be designed and built, everything is okay the way it is, except some of the other things about the system, as Jonathan mentioned. But if additional changes come about, okay, then how do we approve that between WCID and Kerr County until it's all given over to Kerr County? I mean, to WCID. So I move for approval.
Second.
The motion's been made by Commissioner Moser and seconded by Commissioner Letts to approve the amendment to the interlocal cooperation agreement between Kerr County and Kendall County WCID number 1. That's the motion that's before the court at this time. And just to take a couple of steps back and remind the public, WCID number 1 in Kendall County is the entity with whom we've gone into joint venture or partnership with on this wastewater line, and they're the ones who have operational control of the line. It looks like to me what we're doing here is clarifying the engineering firm and any other designee to require Kerr County approval, which we would absolutely want to do, I would think. And with regard to additional construction or operational control, anything to do with the line that we own, we have a say in what's to be done with that, but everything on the other side of the county line is completely up to WCID number 1, as I understand it. Is that correct?
Correct. And
So
there
this
is
is just clarification.
Right. And there is an exclusion that says the last sentence at one point in the first part of the definition, individual residential or commercial connections to the wastewater system shall not be considered additional construction. If no, a house gets built in Center Point on a vacant lot, that's not additional construction. That's just tying into the tap of the existing line, and that's why I put that in there. So it doesn't, and that was the original intent of the agreement. That's what the reason it said operations, that we really originally wanted to hand off all of that to WCID. But now after looking at it, they agree we ought to have discussions if there's a large, development, whatever, so that we need to look at it together.
Well, and one of the things we're going to consider later is expanding that line.
Right.
And we want to have some sort of operational say-so
Right.
of what happens out there. And this preserves that in this amendment, and it's
Right.
agreeable with WCID number 1, Kendall County.
Right. They'll need to approve it, but we had verbally visited with them, and they did not have a problem with this at this point.
Judge, the only thing I would add to what you said, you had a good summary of what it is, that when this line is eventually complete, the service is eventually complete and paid for, WCID owns it. Yeah.
Correct.
Yeah. We're out of the wastewater treatment business. Right. Okay.
Should it be reviewed by the county attorney?
It has been.
Oh, it has.
Yes, this one, yes, sir.
Not that I don't take your word for it, Commissioner Blatz, but
Okay. Good.
Okay.
Okay, any other discussion? Those in favor, raise your hand. Unanimous, 5-0. Let's move on to item 1.24, consider, discuss, and take appropriate action to amend the employee handbook holiday policy and to incorporate an inclement weather, emergency weather policy. Ms. Doss, we've got several for you, so don't go anywhere.
Okay.
This is the first one.
Good morning. In light of recent events with the county closure due to the ice storm, we thought this would be a really good idea. We have the blessing of our TAC HR consultant as far as this verbiage goes, and Heather's looked at it, and I know y'all have had your packets to review. So I don't know, it's very lengthy, I'm not sure y'all want to read it, but if you have questions.
Well, if you could just give us a summary of what is it we're trying to do with this policy change?
If basically, if the county is closed by the court, and admin leave, the people that are sent home get paid admin leave. Anybody that comes into work gets paid for the time that they worked in addition to the admin leave.
If I can add that after the storm, there were folks who had to come into work and were getting paid the same as other folks who were staying home, didn't have to work. And what we were asked to look into at that time was, could they be compensated for that time that they came in addition to their regular pay. And because we didn't have a policy, it was not permitted. Violated the Texas Constitution. So that's when we shifted gears and got with TAC and created this policy.
And so that the public understands, we visited this issue earlier with the storm, and we weren't able to do anything because it would violate the Texas Constitution.
Yes.
So we sent it back to HR and to County Attorney's Office to come back with a proposal of how we might be able to address this in the future.
Correct.
And this allows that when the courthouse is closed, like it was during the winter storm, the snowstorm, and people are sent home, they accrue administrative leave. But for those people that had to come in and work back during that storm, they got paid the same thing as the people who didn't work.
Correct.
And we didn't think that was fair. So now we've established a policy that would allow those people to be compensated if they come to work when the courthouse is technically closed.
Correct. For those hours worked in addition to the admin leave.
Which only seems fair.
And it also talks about the regular holidays, county holidays that employees are required to come into work. They get the holiday pay in addition to the pay for their hours worked.
Okay.
Like the sheriff's department does.
Basically, it's a fairness issue.
Sure.
Whether it's a holiday or whether it's a day that the office is closed. It's a matter of saying that if you are required to work and someone else is not working at all, it's not fair to pay them the same. So you need the person gets the holiday pay and then they get paid for the hours they work.
Right.
And it's similar. The sheriff's department has always had this. This is basically expanding and modifying the policy of the sheriff's department to all county departments.
Correct. And it also takes into account exempt staff. If you're an exempt staff and if the county's closed and you're required to work, you will get paid for your time as well.
Okay.
Well, this is really a lessons learned policy change.
I move for approval.
Second.
Motion's been made by Commissioner Letts and seconded by Commissioner Moser to approve the amendment to the employee handbook holiday policy for inclement weather and emergency weather policy. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0.
Thank you, the employees will really appreciate that.
Frankly, this was a no-brainer. We had to do this. So moving right along, let's go to 1.25. Consider, discuss, and take appropriate action to approve changes to the payroll change notice form to incorporate position schedule budget guidelines. Another lesson learned modification.
Yes. This does add the verbiage.
Put it in water.
That pay request in excess of budgeted position, schedule, salary must have prior approval from Commissioners Court. If we receive these payroll change forms and the salaries are higher, like for mid-year hires, other than change of budget year, it has to come to Commissioners Court. There's also area that down here that you have to fill in if the Commissioners Court required, approval was required, and then you have to rotate the court order. So.
And again, this is the lessons learned from our experience with hiring a new assistant district attorney recently.
Correct.
That what our policy provides is if the new salary is the same or less than the salary position, that's permitted. But if it's more than that, it's got to come back to the court.
Correct.
And this merely just spells it out in black and white, so there's no question about it.
Correct. Now, there could be situations where there's a transfer from another department and the step is higher. So if the person has more longevity, they come over, there could be a situation where they would get paid more, but in the same grade pay. So I don't know if y'all want those to come back to court as well. Because we typically use payroll contingency funds for transfers where somebody comes in at a higher step. So that's up to y'all.
I think the intent was to make it crystal clear to everyone at the county that any increase in salary will come back through and have approval by the Commissioners Court.
Okay. Okay.
No, not decreases, just increases.
Correct.
Any other discussion?
I move for approval.
Second.
Motion's been made by Commissioner Letts, seconded by Commissioner Ballou, to approve the payroll change notice form to incorporate position schedule budget guidelines. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0. These are just lessons learned, folks. We have to do this. Item 1.26, consider, discuss, and take appropriate action to amend the employee handbook to clarify longevity and certification pay effective date. Ms. Doss.
Correct. There's been some confusion. Some people read it one way, others read it another. When the longevity and certification pay comes into effect, the current reading is the payroll following the anniversary date. So several of us feel that that's pretty self-explanatory, but say your longevity date falls on a Monday and the pay date's Friday, well, payroll's already been processed on that Monday. So we would like to change that to the pay date following the full pay period after the anniversary date, and as well as any other, the certifications pay. The pay will be effective the following full pay period after the earned certification date. Rather than have 4 days paid at this rate and 6 days paid at that, we'll just make it clean, the full pay period after the anniversary date.
Again,
Right.
clarifying lessons learned. So
Yep.
that there's no question of when that's going to hit your paycheck.
Right.
Move for approval.
Second.
Okay, motion's been made by Commissioner Letts, seconded by Commissioner Harris to approve and the amendment to the employee handbook to clarify longevity and certification pay effective date. Any other discussion? Those in favor, raise your hand. 5-0, unanimous. Item 1.27, consider, discuss, and take appropriate action to approve the human resource procedures and to include them in the supervisor handbook. Ms. Doss.
Yes, this is a whole new information sheet that we would like to provide to incoming supervisors. It has a little blurb under payroll and budget procedures about the new hire and the transfer and any positions that come in mid-year need Commissioner's Court approval at a higher, that want to come in at a higher salary. It also talks about how we handle orientations and the hiring procedures that we should have had in the manual to begin with. So I just like to add this one sheeter into the
Specific clarifications on lessons learned. Let's just spell it out in black and white.
Okay.
We can call those continuous improvement too.
Yeah.
Continuous improvement.
Continuous improvement.
I move for approval.
Second.
Motion's been made by Commissioner Harris and seconded by Commissioner Moser to approve the human resource procedures and to include them in the supervisor handbook. Any other discussion?
Just a quick comment. I just wanted to note that the county attorney and the HR director for spending a lot of time on this. They worked back and forth. I sat in on some of the meetings, but all good work that really clarifies our policies. I appreciate it.
And I want to echo that because it's hard enough to make some of the decisions that we have to make on this court. It makes it a whole lot easier when the rules are spelled out clearly in black and white And we've learned from lessons, and we know that exactly what we can and can't do, and when we should do it and shouldn't do it. So thank you.
I'm gonna ask something, and the county attorney can tell me if I'm getting off our topic here, but there are also supervisory reductions in pay, and I don't know if we have a policy for that. If you have a supervisor that decides to reduce pay on somebody, then do we have a policy for that? Because that also can create problems.
This might,
This seems to me it kind of
Only
covers.
for increases.
this is only for increases, but this might be resolved in that, when the court considers and adopts measures that are recommended by the salary survey, I think that what y'all are looking at doing is adopting a range. And so you can, if you'd like to put into your policies, if supervisors are gonna go in and make recommendations that are below the range, they can.
See, that messes things up again.
Yeah, it does.
So I think we ought to have a baseline. And
But I
that
think we're
should
getting
be
outside the
included.
scope of this agenda item, weren't we?
Well, yes and no, because if something's in the supervisor, this was the point of this provision for the supervisor handbook, to tell supervisors, because I think that's where we run into problems with newly elected folks coming in and maybe not newly elected, didn't really know that that was her responsibility to come to the court and ask for permission to do these things. So that if that's a policy you guys want to also adopt, we can put it into that handbook and they can, the newly elected officials or appointed officials.
But I thought Harley's point was they have to come to the court to increase, but not necessarily to decrease.
And I think it should be
Yeah.
both.
Yeah, your point was
I mean,
decrease.
if you're gonna take somebody that's currently at a certain level and say, we're gonna reduce your salary.
Right.
And that could be for a lot of reasons as a supervisor, but it should, I think, be explained, and shouldn't just go one direction with it, I think, maybe.
Right.
Well, there's kind of a difference between the non-exempt folks, because the positions themselves have a grade set to the position. So to get a grade lower, then
We
that
have no
would,
policy.
excuse me?
We have no policy on that.
Right, but if you're gonna hire a non-exempt person, but the positions are aligned with certain grades. Now, what we get in trouble where there's no step in grade, folks, we have a lot of those that aren't on the grade step. And then for those, there could be a range, that's what we're
But in
talking
my
about.
mind,
having a
Jennifer,
range.
it affects the productivity and efficiency of the county. And that is what we're here to focus on.
I understand what you're asking, I think, and if you'd like for us to work on a policy like that and present it to you and talk through what that might look like on the other end, we're glad to do that.
I would, I don't know about the rest of the court.
That's a good
I think
idea.
that'd be a good idea.
Just to be clear, the general provisions in our budget adopt that salary position schedule, right?
Right.
And if anybody wants to increase that, they're gonna have to come back to court. We've established that, and that's now part of our
Right.
manual, correct? And what we're discussing now is any potential decrease in salary,
Correct.
which heretofore had been within the discretion of the department head or elected official. But if we change that policy, it could come back to the court, and that's what you're suggesting.
Yes, sir.
Commissioner Blue, is that we take a look at that. But that's not something that we're acting on today.
No.
That's what I want to clarify.
Right. But I wasn't sure if that would fall under this agenda item, so, thank you.
Okay.
You're welcome. So we've got some marching orders, we'll
Okay.
have a look at it and get back to you.
But what we have before the court right now is a motion and a second to approve the revised supervisor handbook as presented, which does not include this decreasing salary situation. Is that correct?
Correct.
So with that, is there any other discussion? Then those in favor of as presented, please raise your hand. Unanimous, 5-0.
Okay, I'll make
And we
sure.
will follow up on the other results.
Yes, sir. And I'll
Thank
make
you.
sure that the county employees receive all this information. I'll get it out to them today.
This is all very important work in running the county, so thank you very much. We can probably do a couple of things before the break. Let's look at 1.28, which is consider, discuss, and take appropriate action, determine whether to allow the retail fireworks permit holders to sell fireworks to the public beginning May 1 and ending midnight May 5 in celebration of Cinco de Mayo. How are
checked.
our fire conditions?
Well, I checked them this morning and they're good, so I move for approval.
Second.
So motion has been made by Commissioner Harris, seconded by Commissioner Baloo to approve the sale of retail fireworks to permit holders from May 1 to midnight May 5 for Cinco de Mayo.
Is
Any other
there
discussion?
the intent to have a limitation on skyrockets and
Missiles with fins.
pins and,
What's the?
No, because the rating is
okay, okay. it's the
4 to
issue.
500 right now, and so we're not in that critical stage, and so,
Okay, all right.
yeah. No
No handicaps,
handicaps.
I just wanted to clarify, okay.
Okay, so we've got a motion and a second to approve this. The only thing that I would add is, for those of you that are going to use fireworks, please be careful.
Sure.
Legally, we're approving the sale of it, but especially when you start getting these missiles with fins and shooting stuff up in the air, landing on other people's property and roofs, it can be very hazardous, so
Question,
just be careful.
I'm sorry.
Go ahead.
Can we change that if drought conditions warrant?
Worsen?
Yeah, before, like, right before May the 1st?
I would ask our county attorney that.
We've got some time deadlines in there.
You probably have some time if you have a meeting by then. The reason that it's here today,
Yeah.
for you to consider allowing it at this time is because the law says it has to be done
Sure.
on the 25th of the month for this particular holiday. So if drought conditions exist later and you have a scheduled meeting or you need to schedule a meeting, you can do that.
Okay, so we could change it if we
I think
need to
so.
based
I
on
thought that was the
conditions.
case, but I wasn't for sure, but
Okay.
yeah.
Okay, good enough.
Okay, then those in favor, raise your hand. Unanimous 5-0. Another quick one, let's go to item 1.29, which is to consider, discuss, and take appropriate action to accept the certificate of course completions for the Open Meeting Act and Public Information Act.
Bradley.
Brad Ryder, is he outside? This is Constable Precinct 4.
As he's coming in, is this a court action?
Yeah, I was wondering, I asked Jody about this the other day. I said, because
I
I went
don't
to
know.
some things and got certified and we've never bought it.
Yeah,
before.
right.
We don't have to
I
approve.
did place it on the monthly reports.
Huh?
I did place it on the item for the monthly reports.
Yeah, but the question is on this agenda item,
I agree, but it's regarding this agenda item. And in the event that the court doesn't take action on this particular item, it can be accepted through monthly reports if y'all would.
that's my question.
I would
Why
think
don't
in the
we bring it
future.
up for
I think-
court action?
You're not required to.
Okay,
Okay.
Actually, I think this is probably the first thing that our new constable has requested
Right.
that we approve.
well, I don't think we ought to
As a matter of form.
set a principle here.
I agree.
Yeah.
I think we
Precedent,
should.
I should say.
Acknowledge receipt.
Yeah,
Yeah.
acknowledge receipt.
Now, that'll just be read in the monthly reports next meeting.
Probably
Is
this
it a monthly report or is it a certification?
It's a certification, and I think just to be on the record that it got done, I think that's.
No, that's my
but
point. I
know
don't think
if
it should
it's-
be a
I don't know
record.
if it's required like
Yeah.
the county attorney stated. It's not
Yeah.
necessarily required.
We got everybody in the county that
It-
has to
it's-
do that.
So
It's-
then, on the monthly reports, if you would mark out that line, it's number,
No action.
I mean, if that's what y'all want to do on that, I would say, mark out number 7.
7.
Yes,
We'll get to that when we get to monthly reports.
thank you.
Because it's documented in your office anyway. I mean,
Yes, I file stamped it.
Right,
I'll have
okay.
Okay,
it.
so no action.
Okay, with that, I think we've gotten to the appropriate time to take a break. Why don't we take a break for about 5 minutes, be back here right at 10 o'clock, and we'll start at 10 o'clock again. Court is in recess for 5 minutes. Court's back in session. We're going to move to our timed agenda, the 10 o'clock agenda. The first item is 1.12, consider, discuss, and take appropriate action. Commissioners Court approval regarding 2 Kerr County agreements for storage of Kerr County-owned materials and/or equipment. The locations are 495 Scenic Hills Road North in Precinct 1 and 135 Cutbirth Drive South in Precinct 4. Ms. Hoffman.
Thank you. Before you are 2 Kerr County-owned materials and/or equipment agreements for temporary storage of materials and/or equipment on private property for the locations of 495 Scenic Hills Road North, that's in Precinct 1, and 135 Cutbirth Drive South in Precinct 4. Engineering has checked for floodplain on both proposed storage locations. The property owners have signed the waivers, and the county attorney has been made aware of both of these agreements. These agreements are good for 1 year from the date of the Commissioners Court approval. At this time, I ask Commissioners Court for their final approval and the county judge, county attorney, and county clerk to sign the same regarding the Kerr County temporary agreements for material and/or equipment storage at 495 Scenic Hills Road North and 135 Cutbirth Drive South, and these are in Precinct 1 and Precinct 4.
Kelly, is this the same as in previous years? You
Yes,
probably said
yes,
that.
sir.
Okay. And what is the cost of this?
There's no cost.
Okay.
I move for approval.
Second.
Okay, motion's been made by Commissioner Harris, seconded by Commissioner Baloo, to approve the 2 Kerr County agreements for storage of Kerr County-owned materials and/or equipment, which are 495 Scenic Hills Road North and 135 Cutbirth Drive South. Is there any other discussion? Those in favor, raise your hand. Unanimous, 5-0. Item 1.13, consider, discuss, and take appropriate action to discuss road damage and repair options for the winter storm. Is that Uri?
Yes.
Okay. Precincts 1, 2, 3, and 4. Ms. Hoffman.
We sent out the engineer's estimate for the reconstruction costs from road damage from the winter storm Uri. Of the 20 roads that were submitted in our TDM report, 2 of them, Precinct 1 and 2, are roads that probably are going to take a little more extensive work on them. There's a section on Shepherd Reese as you're going up the hill towards the horizon in that area, and then 2.5 miles of Ranchero Road. These are probably 2 of our highest traffic roads. Those roads, what we're hoping is to see what FEMA will give us for funding, and if there's any grants that might be available to help to cover some of the costs on those 2 roads. Would help us out greatly. Ranchero by itself, it would take the whole entire staff to do traffic control and the reconstruction, and it would probably, the guys said, probably about 2 months we would be on Ranchero. Charlie?
It's not in an area where you can detour, is it?
Not really, is it? Is there one detour you could take?
There's one detour, and that would be there at the Nimitz School, Valley View. But it would be a major inconvenience.
Sure.
So Kelly, this is $1.8 million in repairs, so the agenda item is look for options, so what are you proposing?
Well, what, like I said, what we'd like to do is the other 18 roads we can repair in-house and make the repairs on those. On these 2 roads, we'd like to see what kind of funding that FEMA will give us after the final reports have been submitted. And my understanding is FEMA will probably send a representative out to look probably at those 2 roads.
So what action do we need from the court?
There really is no action. I just kind of wanted to update you, let you know what we have.
So it's for information?
Yes.
Okay, good.
And the direction we want to go. Charlie has an agenda item. We are going to have Rock Engineering come in and do core samples in those areas to find out what's been damaged. It doesn't necessarily mean if you've got 14 inches of base that all 14 inches have to be removed. They may say our recommendation is to remove the top 3 inches and maybe put an additive in with the new 3 inches and
so you'll come back when you decide what to do?
Yes, sir.
With the option. Okay, good.
Going on the other 18 roads that we're going to repair in-house, to do that, you're taking 15 miles off the Silco program. Is that,
Well, some of those roads are on the Silco for this year. They happen to be on the Silco list. A lot of them are not large areas. It would be very similar to roads that we have base failures in certain areas that we've got to cut out and rework that spot. Am I correct on that?
That's correct,
Really?
that's correct. The majority of the damage is very small, spot here, spot there, and we're talking, the size of your table, stuff like that. And that's more maintenance than it is reconstruction or real arduous task, so.
The real major damage is those two roads.
is there any way to not take 15 miles off the Silco program?
Oh, we're not gonna take 15 miles off of, no, what it is that we took this year,
Oh, you
we
already-
reduced it to 35 miles to try to help the court
Okay.
balance the budget.
All right.
We
You're not
normally are in a 50 mile
Okay.
program. We're at 35 this
You're
year.
not reducing it in addition?
No, sir.
Okay.
No, sir.
Obviously, addition was after that.
No.
So Kelly, what kind of timeline are we looking at to get, people out for core samples, and when you think FEMA or somebody might come out or what have you?
Well, I think the FEMA coming out would be after the reports are submitted, I think on April 19th. And then FEMA, I think, goes from there, and they come out and they want to look at the road damage, is my understanding.
And there's a workshop tomorrow for that very discussion that I saw right before I came into court.
And with today's technology, my understanding is talking with Dub, they may not come out at all. They may rely solely on pictures that we have taken, video, the reports that we provide, and that's why we got to jump on those reports. They're turned in. That's all turned in, and we're waiting to hear back from FEMA on that. But we do have another item, 1.22, and it is still listed at 10 o'clock. I don't know if y'all want to pull that out of order, just take a moment.
That's up to
if you'd
him.
like. So otherwise, it's at the end of all the 10 o'clocks.
Well, let me make sure, first of all, on item 1.13, we're not taking any action today. This is
No, sir,
information only.
it's just for information.
And thank you for letting us know. You know how we hate surprises.
Right.
But this is all part of the public assistance portion of the FEMA grant applications that we have in.
Yes, sir.
Okay. So since there's no action on 1.13, let me go ahead and call item 1.22, which is related, and that is to consider, discuss, and take appropriate action for the court to authorize the county judge to execute a contract with Rock Engineering Testing to perform a geotechnical pavement evaluation for roads damaged in Winter Storm Uri, 2.5 miles of Ranchero Road and 0.4 miles of Shepherd Reese Road, precincts 1 and 2. Mr. Hastings.
Thank you, Judge. Winter Storm Uri swept through the Texas Hill Country beginning February 11th, 2021 and ending February 19th, 2021. The storm included freezing rain, snow, ice, sleet, and sub-freezing temperatures. Water that infiltrates the surface of a road through micro cracks expands once frozen, opening up the cracks, making them larger and deeper. Once the ice thaws back into water and freezes again, the cracks are made larger again. We saw a lot of that on the roads. At night it'd be frozen. In the daytime the sun would come out, it heated back up. That water, and every time, was making those cracks bigger and bigger. This, combined with heavy traffic, resulted in extensive base failures and a washboard surface for portions of both Ranchero and Shepherd Reese Road. As a matter of fact, if you would have driven down Ranchero and was over, we were describing some portions as a cobblestone path. It looked bad, okay? We did get a comment from someone in the public that said, that's great, people aren't speeding. But we got to rebuild those roads. We can't leave it like that. Both roads will need to be reconstructed. A pavement evaluation from the certified geotechnical engineering consultant is warranted. Please see the attached proposal from Rock Engineering and Testing Laboratory Incorporated. We've used Rock Engineering over and over again. Very good geotechnical firm. And the county attorney has something to add because she put a small contract together for you
We
all.
put that small contract together, that's probably what's in your packet now, but I've made some modifications to it to include some of the provisions that are required in order to get the FEMA funding for it that Tanya sent me last week after she got some education about FEMA requirements for this public assistance. So you'll see those in there. I sent that to Jody today, but that's what you'll be signing, and there are just maybe 6 or 7 provisions that I added to that small contract.
Now, what you approved today is not contingent upon getting FEMA reimbursement. There is money in the budget and the Road to Bridges budget for these kind of things. We do these sort of things routinely. The county engineer recommends that the court authorize the county judge to execute a contract with Rock Engineering and Testing Laboratory, Inc. in the amount of $3,500 to conduct a pavement evaluation for the reconstruction of 2.5 miles of Ranchero Road and 0.4 miles of Shepherd Reese Road.
Move for approval.
Motion's been made by Commissioner Moser, seconded by Commissioner Letts, to approve retaining Rock Engineering and Testing to perform geotechnical pavement evaluation for Ranchero and Shepherd Reese Roads. Any other discussion? Those in favor, raise your hand. Unanimous, 5-0. Thank you very much, Charlene.
Welcome.
Okay. Ms. Carr, if you're watching me upstairs, this is the time that you should start directing your people to come downstairs. I'm going to call item 1.14, which is a public hearing for a revision of Plat for the Ravine, Lot 21, and a portion of the common area. Mr. Hastings.
Thank you. I think what I'd like to do to introduce this, this has been through one public hearing during the snowstorm that had to get canceled. So that is why we are here again today. The Ravine is an existing subdivision. They'd like to modify Lot 21, making it a little bit bigger, coming out of property from the common area. The bylaws in the subdivision reference an area as common. It is owned by a single owner who originally was the developer of the property. That's changed hands a few times. But if we're ready, I would like to open it up for let the public come speak.
Okay, at this time, the court will convene a public hearing for the revision of Plat for the Ravine, Lot 21, and a portion of the common area. First person I have here is Bruce Galloway. Mr. Galloway here?
He's right here.
Mr. Galloway,
Yes, sir.
you may proceed.
I am trying to buy an additional tract of land adjacent to mine, have it all replatted into my name in one plat, for so that if I ever decide that I want to sell this piece of property, my home and property, it'll be a clear deed.
Let's back up. The public needs to know what we're talking about. This is a public hearing.
Okay, I'm sorry. We're talking.
If you would just summarize what it is you're asking the court to do. And why.
All right. I'm asking the court to approve a replat of Lot 21 in the Ravine subdivision over on the other side of Ingham. The land is noted as common area, but in fact, title to the land, the deed to the land is in the Ravine Development Company or Daniel Hawkins. The people that are opposing what I'm doing are saying that the restrictions don't allow it. There's nothing in the restrictions that says that the owner of the ravine cannot sell property. There's no such language in those. All I want to do, and the reason I'm wanting to buy this is my septic line runs into the common area. That was approved in 1994 by the Commissioner's Court of Kerr County. It was never made a matter of public record, but about 2 months ago, I gathered all the papers from the Commissioner's Court and put them in a form of an affidavit and filed them as a matter of record in the deed records of Kerr County. And all I'm asking for is to be able to buy this piece of property so my septic system lies solely on property that I own. I'm not making any future developments of it. I'll clean up the property a little bit. I'll make it look a lot nicer than it was. But anyone that says that Daniel Hawkins can't sell this land, the Ravine Development can't sell it, it's in his name, and there's nothing in the restrictions that says he cannot sell this property.
Mr. Galloway, did you bring an attorney or engineer with you today?
No, I also happen to be a lawyer.
Is there anything else you'd like to present to the court?
That's it, that's all I have, sir. I appreciate you taking your time to listen to me.
Judge, I'd like to add that what Mr. Galloway has just stated is found in Exhibit A of the next item, just so you know. He described that he had permission at one time to have his septic system off of his property into the common area. So just wanted y'all to know that that is available, and when we get to that next item, after the public hearing is over, I'll refresh the board on that.
Okay. Then the next person that has signed up to speak is, I'm trying to read this, is it
Catherine Bach.
Catherine Bach? Bacher?
Where on this is
Hello.
Hi.
Sure.
Please identify yourself. and
I'm
name.
Kevin Walkover.
Okay.
I've been in the Ravine for over 20 years and seen the good and the bad and the evil that's come out of it. And right now we're struggling with the evil. I asked the court not to consider against the replatting. And I just don't understand that we've gone all this time, we've had no problems of a septic, or we've all gotten along, there hasn't been any problems, and all of a sudden now, we decided we want to start chopping things up. And I know that the owner, Ann, wouldn't have approved it, and I don't understand why we can't work together and why we have to be so, it's just not pretty right now, but I am against the replat.
Ms. Bachhofer, could you describe for us what is the common area as you understand it there in your subdivision?
My understanding of common area is any land that anybody can touch, walk across, do whatever to it, because I've never been restricted anywhere on my property or off the property or down at the waterfront, nothing. So all I was understanding that my house is number 8, so there's a lot in front of mine, and then down the way a little bit there's a couple other lots, and then I guess lot 21 down here. But I was understanding that I didn't realize there was gray area, and I thought everybody who lived in the ravine had access to whatever, because that's how it was. No one had any issues.
It was all common use?
Everybody used it, yes. The only, like I said, 20 years I have had no problems. No one, saying this or that. And like I said, and all the beautiful scenery that was out there, all the woods and all the pine and all the animals, he came in and just took it out. I don't understand what for. And now, because there was, when I first moved there, there's a family of mama deers, and they would come up every year, and now you don't see anything. And it's just dirt, rubble, and I don't understand why he came in and took it up. There was no reason.
Is the common area and the use, common use by the residents of that subdivision referenced in your deed documents?
I couldn't say that for sure if it says that, but I'm understanding that it does, but I didn't understand. I was never told even when I rented, because I rented part of the time and I just recently bought the house. So when I was renting, everybody had used to everything. It wasn't like you can't step here, or there. It was all open. And all of a sudden now it's like, you can't touch here, you can't touch that. But I just assumed everybody had access to the waterfront. But I guess we don't have that.
Well, we'll see.
Okay, thank you.
Thank you. The next person is,
Thank you so much.
I think is it Delma Ibarra?
Good morning.
Please state your name and address.
Yes, my name is Delma Ibarra, and I live at 127 Akinlot Road, Lot 9. And I'm against the replant in the ravine. So I'd like to also say a little something. I just recently moved about 2 months ago. And when I saw the area, I mean, to me, it's just beautiful. If anybody, if you're familiar with the area,
Yes.
it's just a beautiful, quiet, serene place. I'm still employed, but I do hope to retire soon. And that was my dream. The reason I bought my home there is to be able to retire because it's just so beautiful. And I have a family, I have grandchildren, and I want to, I don't want anything else to change. Anyway, that's all I have to say, so.
Can you clarify something? There was mention of not having access to the water. Now, is that the only place where you could have access to the water? This part in question is less than a half acre, it looks like. Is there any other place where you can have access to the waterfront?
No, sir, that I'm
Okay.
I'm still getting to, need to get more familiar with all the area too, so that, yes, sir, that I'm aware of now.
Is this common property, is it described with meets and bounds, so we know exactly where it is? Huh?
Charlie will give us more information.
Okay.
during the discussion.
Okay.
Yes, it is in the-
Okay.
Thank you, Ms. Ibarra. Next is Audrey Robles.
Hello.
Ms. Robles.
Hi. I'm Audrey Robles, formerly Audrey Carr, my maiden name. I'm Ann and David Carr's daughter, and I'm against the replatting of the land.
And tell us why.
From what I've heard, it does not sound appropriate.
Okay. Is there anything else you'd like to share with the court?
I love the property, I love the ravine, and I don't want it to change. Thank you.
Thank you. Next is Miss Ann Carr.
Good morning. My name is Ann Carr, and I live at the Ravine, and I own Lot 6 with my husband David. Even though we've only owned our home for less than a year, my family and me personally have been coming to the Ravine for over 35 years, as my grandmother lived here, and our family has been coming to the Eichmann's Rock House for about 20 years. First of all, I ask that the court denies this replat. Secondly, I've got to say thank you. I got to thank Don, and I got to thank Charlie. Right over there. He really put up with me and Miss Jody because there were times during this where I really needed some help. Y'all's patience and kindness towards me, and even when I didn't deserve it, has helped me learn more than I ever imagined about how things work here at the county and about our restrictions. I've learned that Anna Eichenrod is the subdivision grantor. She created the restrictions, and she set aside certain reservations for herself where only she had the power to change things at the Ravine. These things included utility easements, the road, or common green areas. Her authority as subdivision grantor lasted for a period of 25 years. After that 25-year time period, she set up a unique mechanism for change, and that system involves a 2/3 voting system that can only occur every 10 years, and that 2/3 means we have to have 16 lot owners vote for the approval. No other grantor, or in Mr. Hawkins' case, deed or title grantor, has the right to change anything at the Ravine. Only the 16 lot vote majority can change things. I've also learned that our restrictions run with the land, and they are part of the land, and that even if our restrictions are not included in a deed transfer, that lot owners have the same rights and privileges set forth in this document. And during a deed transfer, these restrictions cannot be tampered with. They are set out in full in each and every contract and deed. A new owner cannot delete certain restrictions that he or she doesn't want included in the sale. These restrictions come as they are. They are a package deal. A new deed grantor must accept the complete reservations that are on file with the county. The new deed grantor cannot manipulate this document of record at closing to fit their agenda. I've also learned that when you buy property, you are subject to the restrictions on record, and you cannot say, well, I like this restriction, but not that one. We, the lot owners, all signed papers at closing that included our restrictions, and those restrictions on record with the County of Kerr have not changed. Since the deed transfer from grantor, including the deed transfer from Larry Martin to Daniel Hawkins in 2016. Also, regarding that very sale, Scott Peschel, the then Vice President of Fidelity, titled, that was the title company during the sale, from Larry Martin to Mr. Hawkins. Mr. Peschel stated that Daniel Hawkins only has a title of grantor of the common area, but no power to sell or manipulate the grounds. In closing, I'd like to thank you for this time, patience, kindness. I'd rather not be here today. I'm missing work. But if we were going to fight for our property rights, I can't imagine having a better group to be here with than my neighbors and my family. We are simple people here just like y'all. We're government employees, we're teachers, nurses, counselors, musicians. A lot of us are retired. We don't have a lot of clout or money, but we do have each other, and we have you. This court that's set up to help people like us. Thank you again for your kindness.
Thank you, Ms. Carter.
Good summary.
Next, David. Please identify yourself and your address.
Hi, yes, sir. Good morning. I'm David Carr. I, first of all, wanted to say thank you for giving me some time, just a few short minutes of your precious time and I'm also with my beautiful wife, lot owners in Lot 6 at the Ravine. I'm also an engineer, electrical and environmental engineer for 32 years for the United States Army. We protect and defend the United States, and today I was supposed to be briefing the Pentagon, but this was very important to spend some time to address one particular issue, because I know you're going to be listening to several people. So I just want to address one particular issue, and that is taxes in the green area. I gave you some papers there. The first page is just straight out of the record, volume, I think it was volume 175, page 568, section 22. It goes on to say right there, first of all, that, let me just back up, I oppose the...
Let me just clarify. This is a copy of the page of your restricted covenants?
Yes, sir.
Yes, sir.
Yes, Judge. I oppose Lot 21's replatting for this, for many reasons, but this is one of them, because it's going to encroach on a common green area. It's going to swallow up a small portion, but a portion of it. And I have a say in that. I haven't been asked to do that. Right there in what I highlighted on that page talks about maintenance and improvement. Each lot shall be subject to an annual maintenance fund, said fund to be collected, administered, and dispersed. It goes on to talk about in determining the annual amount chargeable to each of the lots. And then it goes on further and saying, for the common welfare of all the lot owners. This fund shall be used for the purpose of improving and maintaining the roads, walks, common green areas, easements, and maintaining or expanding the water system, or doing any other things necessary or desirable. I'll just stop there. And I provided some copies of bills from history, didn't give you all the bills, but what I gave you was a history that at one time the lot owners paid their share of the taxes, and then it stopped. And I've only been a lot owner for less than a year, so I don't know all the history, but I can see in just looking at the bills that they did pay the taxes. Daniel approached me a couple of days ago, and I wrote it down because he said he pays all the taxes, he takes care of this place, and I can go on and on. However, I'm going to cut it short there. I didn't ask him to pay the taxes. For these reasons and for other reasons, I asked the court to stop the replatting of the ravine. Although we have been homeowners for a short time, we embrace the restrictions and we respect them. Ann Eichenroth was an amazing, brilliant person, and I've learned so much about her. I wish I would have known her personally, but I don't. So I'm trying to preserve what she tried to do there at the ravine. So I'm just one of the 2/3 in the deed restrictions that has a say. At least 2/3 have a say. And I do not agree with the replatting into the common area because it's mine too. And I thank you for your time very much. Thank you. And I thank my wife for all the hard work she did.
Who owns the common area?
The ownership, I believe, is Mr. Daniel Hawkins or Ravine.
But it's not the homeowners association.
We technically do not have an HOA, sir. We have a maintenance fund, and so we don't technically have an HOA, but we do have a maintenance.
But who owns the property? Who owns the common land?
Mr. Come up in Mr. Hasey's office.
Yeah.
Can I not ask questions?
Generally, we don't ask
Huh?
questions during public hearings.
Okay. Withdraw that question. I'll answer it in a minute.
Thank you, Mr. Carr.
Thank you very much, Judge. Thank you.
Next is Eric Eichmann.
Good morning. My name is Eric.
State your name.
Oh, my name is Eric Eichmann, and my grandmother owned Lot 3, and now my aunt and uncle Scott and Eichmann loan Lot 3. I've been going since I was born, so 40 years. I'll be 40 this year. I do not agree with this replatting of the land. As everybody in front of you has said, it is common ground. It is for the enjoyment of everybody, families, our friends that come. And we, again, I've been coming since I was born. My kids are now 16 and 2. I bring my kids. And, you know, some of the restrictions are with this, you know, selling this piece of land could lead to selling another piece of land, and it will hinder our ability to go to the river if that comes to, or inhibit other activities, you know, that our families can enjoy at this place. And like I said, Ann Eichenrod put into her deed restrictions that her restrictions were forever. For whoever owned that land, those restrictions were forever. So,
let me clarify.
Yes, absolutely.
Ms. Eichenrod was the original grantor that
Yes.
set this system up?
Yes, sir.
And she imposed those restrictions on herself forever?
I don't know if it was for herself. From what I read, it was to whoever that land went to after her. It was forever in that respect.
And so your understanding is those covenants run with the land?
Yes, sir.
Okay, thank you.
And I thank you very much for your time and taking the time to listen to me.
Thank you. Lauren Eichmann? Did I get the first name right?
Yes, sir. Lauren Eichmann. Good morning, everyone. I am Lauren Eichmann. I own lot number 3, along with my husband, Scott Eichmann. His mother was the original owner of our property, so they bought that property, Van Buren, in '74. It was deeded over to my husband and I prior to her death. We have a lot of ties to the Ravine anyway because my grandmother had a house, I don't know when it is. Anyway, bought Coben's house. Long story short, y'all have been hearing the same thing. I just more or less want to ditto everything else that everyone has said, but I'm opposed to the replat. We, as you know, the common green area, it's not very green anymore because of the storm, but it's all brown sort of. But the green area, the common area, is we have access to. We always have up until about a month ago when my husband and I chose not to do the original plat back in February 22nd. We were part of the number 3. We wanted to also expand our lot, like Mr. Galloway. But in reading the deed, our Bible more or less, our Constitution, the restrictions, shows that the family members, lot owners, have use to the common green area. My husband and I just wanted a little teeny tiny pie, and after reading our restrictions over and over again, you can't sell common ground. It wouldn't have been right for my husband and I to purchase land that the other lot owners have access to. That's why we backed out. Sorry at the last minute, but we did. It wasn't right. So that's all I want to say. Thank you for your time. Definitely do not oppose or don't oppose this deal. Reply. Thank you.
Thank you, Ms. Eichmann. Scott Eichmann.
Hi, good morning.
My name is Scott Eichmann. I'm a lot owner of 3 with my wife, Lauren Eichmann. And we are against the replatting of the ravine. I want to thank you for allowing me to speak this morning on this topic. I also want to thank God for giving us this opportunity, because without Him, none of this would be possible. I'm very passionate about things that I believe. And this was one strong moment in time that I'll tell you that this is not the right thing for our community. My history with this property goes back almost 40 years. My parents and their parents own this property. My kids will eventually have this property in our trust. It's written very clearly not to sell this property. They can't agree, they'll have to sell it to each other. It will go on forever in our family, with their kids and their kids. I'm also a graduate of Charter College. I've been a part of this community since 1988. As far as living in the Ravine for almost 2+ years as a student and a student athlete at Charter College. I have ties to this community. I've known every individual that's owned the property, from Ann Eichmann to Catherine to Larry to Daniel Hawkins. Okay, I've seen a lot in my time there as a teenager, growing up in the Ravine, and now as an individual that now owns the property. And I've enjoyed a ton of stuff that you can only imagine that we've experienced over that time. But with the stroke of the pen, somebody can come in and change all that. And you need to know that based on what I can tell, based on interpreting the restrictions, that it would change a lot of things that we experience today, and potentially the future of what my family and their kids may experience. I met my wife in Kerrville. Her parents lived in Hunt. And of course, I also knew my wife's grandmother that lived in the Ravine. Didn't know it at the time, we were living right next door to each other. So there's a lot of sentimental stuff that goes on way beyond just a stroke of the pen that can change things forever. All you need to do is enforce what's already written, and you have it in your hand, which is the restrictions that enforce what Ann Eichmann wished to be. You read it, you interpret it, hopefully you have the knowledge and the willpower to maintain what's already in place. It was registered in 1974 in this town courthouse. The lady was brilliant. If you read how she articulated and put it together, it will stand the test of time if you know how to understand it and know what it means. And I'm sure with the knowledge we have in this room, the people that are going to speak after me, they'll help you understand it more clearly. I pray that the document you have will prevent the replatting of the ravine, that will not allow a private landowner to own common green area. This could potentially prevent future endeavors or future things that the residents of the ravine will participate in. In closing, I can tell you greed and intimidation and conditioning and bullying have been a part of what we've experienced over the last 3.5 years. I initially didn't experience it because I was somewhat on the fence and trying to give the new landlord, I would say the grantee, the opportunity to experience what he thought was his purchase would allow him to do. Over the years, I experienced a lot of stories that changed my path and my feeling of this individual. And up until about a month ago, as my wife explained, we were part of the replat. Because this individual gave us hope or some impression that we could own it at the very beginning when he took ownership, and gave everybody the impression that I'm going to give you part of this land so I don't have to maintain it. Well, it turned out he wasn't going to give it to us, he was going to sell it to us. And over the period of time, I've heard too many stories to tell you that there will be a part of a different day, I'm sure, where this person is bullying and intimidating landowners to buy certain properties or certain portions of property based on certain issues that he believed he had rights to, and made them buy certain things, forced them to do it. threatened to do it. And until yesterday, I never experienced that wrath. Yesterday, he approached me at the riverfront when I was trying my best to improve the riverfront, which I've been maintaining for this individual and the community in goodwill, in good spirit, as part of what I do in life, it's just helping out. I've done a lot of other projects for the Ravine over the years. This individual, Daniel Hawkins, threatened to kick me off what he proclaims as his private property, and he wanted me off of it. And I was in the process of mowing the riverfront. This has to stop. It needs to stop with the replatting, and then we'll take it to the next step after that. But you can't allow a private landowner to own common green property that we all experienced, that Ann Eichenroth allowed us to experience with the joy and the community and our families, up and including the road, the front, the entrance. These are all simple things that we take for granted every day. But if you allow one person to own that property, which we all have rights to it, whether I own one lot or whether I own 6 lots, I have the right to utilize all that property based on how the deed restrictions are written. Very clear. You give one individual that may own the title to it the right to push people around and pick and choose what he wants to do every day of a drop of a hat. It's not fair, and it shouldn't be right. So that's all I have in closing, but I just appreciate the time that you've given us. But if you just read the restrictions that are placed in your courthouse before you were here probably, or maybe not, it'll tell you everything you need to know. That's all I have to say.
Thank you, Mr. Reitman. Al Smith.
Good morning. I am Albert L. Smith. My wife will come behind me. She is Noreen J. Smith. We have owned, and I appreciate the time you have given us. We have owned this property, Unit 10, since the year 2000 when Ann Eichenroth died. Ann Eichenroth was a personal friend of mine. I knew her exceedingly well because I was with her son when he was hit by a car, and I had to I had to identify the body, and he was brain dead. I had to call Ann, never met her. She flew in, I picked her up. She spent 3 days with me, driving her around, and I developed a tremendous respect for her and her brilliance. I won't go into great detail, but she started school at the University of Texas at the age of 12. She graduated within 2 to 3 years. Her son and I both were at Rice. I did not know him at Rice. He graduated at Rice in 3 years with a double major in physics and chemistry and made the best grades anyone ever had at Rice. And that has held for many years. I don't know if it's still there. They were brilliant individuals. Ann did everything meticulously. She knew exactly what she was doing. And so when she died, she willed Unit 10 to me. She had built the house wanting me to move there. She was hoping I would set up a medical practice when I finished my residency in San Antonio, here in Ingram or in Kerrville. My stars were different. I went back to my home where I grew up in the Rio Grande Valley in Lightford, Texas. I went back to the home I grew up in. My parents had died many years before that, and that was my stars. I think she was hurt by it, but she accepted that, and we still remain good friends. When I married and had a child, she adopted them into her family. She was at our wedding. So that's how I knew Ann Eichenroth. I knew what she wanted with the property. She wanted an eclectic community where everybody was a little different but could input ideas and work together. She wanted that common areas to be there for life, for everybody to use. I know that, and I know when this started happening after Daniel Hawkins took over, my wife called Scott Peschel, who was the original title holder of this, created the title, and he said, don't worry about it. He cannot do anything. The restrictions and the covenants and deeds are written in stone. It's the strongest I've ever seen. Nothing can happen. Then we also went to a real estate attorney who we know and respect. he said the same thing. Recently, when he saw what was happening, he said he could not believe it. He said, you need to look to see where the money goes, if you know what I mean. He said, there's no way this could happen unless somebody has changed something that should not have occurred. So we are completely against replatting of this property. Last year, Mr. Hawkins approached us wanting to purchase our Unit 10. Because we were in the valley, we used to come up here for at least once a year, a couple of years, and enjoyed it. But as medicine changed, I had less and less time, and we got up here less and less. So we decided to sell the property. We had, very quickly, we had 2 buyers willing to purchase the property at our offering. The buyers withdrew their offer when they were told by Mr. Hawkins or a representative they would not have a septic tank because he owned it because it was on the common areas. And put several septic tanks in the common areas because she never intended them to be taken by somebody else. And we were told, and so they withdrew when they heard they weren't getting a septic tank and found out what was happening. He then came and offered us 30 to 40% less than what our offering price was. And when we didn't sign it, and he tried to get us to sign it promptly, but we did not, he threatened to sue us for not signing it. And we have a text message where he was talking to a realtor, and he said, you better sell it because he's threatening to sue. I don't know how, that does not intimidate us because we know you can't threaten someone to sue when you are trying to sell something and you're not selling it on their own. So we retained the house. Later we heard that he attempted to replat the common areas around our house, which included our septic tank, without our knowledge. We were never notified or received a letter concerning the replatting of the common area adjacent to unit number 10. The replatting would have directly affected us and Ann Eichenroth's desire to create an eclectic community that would never have the ability for a developer to destroy the habitat she wanted for the common areas and its inhabitants. When the gentleman representing Mr. Hawkins said that, or maybe it was Mr. Hawkins, I don't know, I wasn't looking inside, that he improved the common areas, it was not what Ann would want. He took out some very old oak trees. She wanted the deer, she wanted wildlife to thrive there so we could be part of it and see this wildlife. There are no more deer. The oak trees are gone. And these are very old oak trees. In my mind, that is not maintaining something that we thought was beautiful. He obviously thought it was not beautiful because he plans to develop it. I hope I didn't take much longer than 3 minutes, but my wife is probably going to relinquish her time to me, so I should have a little more, but that's the way it is.
Thank you, Dr. Smith.
Thank you.
Maureen Smith.
Hello. I hope I can project my voice okay. My name is Noreen Smith, and I am the wife to Dr. Albert Smith. And as it stands, I am against any replatting. And the reason I am against the replatting of any of the common areas, which includes the road and all common areas, which I believe is anything that all common areas would include all the land that is not owned by the private homeowners, which includes also the beach on the Guadalupe River. And the reason I'm against it is because Ann, who is the original architectural grantor, she designed everything for the enjoyment and the enjoyment and the use of the homeowners and our utilities, which includes our septic tanks and anything else. And to start replatting it I think is opening the door to additional disasters. And I agree with everything my husband said, and thank you for your time.
Thank you,
Thank you, ma'am.
Susan Nidever.
Hi, my name is Sue Nidever, and I am rather new to the Ravine. I just bought a house there and closed in February, so and found out the day I closed that there was stuff going on. So, the reason I bought the house there is because I'm hoping to get my parents, my elderly parents, to move closer, and I live in Bumblebee Hills, which is just really maybe a mile or two down the road. And I saw this quiet, peaceful, quaint area that, of course, I've been familiar with my whole life driving by there, and I thought, if I can talk them into moving closer, this would be it. And my dad today's his 90th birthday, so, and they are both able to live independently, but I've seen some of my elderly neighbors have medical incidents where I've been helping to take care of them because they didn't have family close, and so I wanted the ability to have a place where my parents could be close. And in the meantime, I have 2 adult daughters living with me, so I'm going to ship them off and they can stay there, and it's going to be good all the way around. I intend this to be a family place. I intended to keep it in the family. I have a brand new granddaughter. I hope that someday it can be hers and she can enjoy the hill country. She's, poor thing, in Austin, so not the same. But I have some familiarity with how homeowners associations work because Bumblebee Hills has one, and I'm actually the treasurer of that one, and so I have read. Believe me, I've read deed restrictions, like studying them, and they're written in some sort of gobbledygook language sometimes, but I've had to read ours at Bumblebee Hills over and over because we've had issues where we've had to deal with, well, what do we do? And what I've learned through that is that one individual's wishes or desires do not override the desires of the community as a whole. And we've had issues in Bumblebee where somebody wants to do this or somebody wants to do that. We go back to the deed restrictions and we say no. And when they're upset, I say, it's for the protection of all of us. It's for the property values of all of us. And so at the Ravine, it's a little different because in Bumblebee, we do have, our common areas were not deeded to any individual, but still, the restrictions are very clear. I read the ones before I closed. I read the ones for the Ravine. It's very clear what Ann Eichenroth wanted and that these areas were to be for all the owners. These common areas were to be available. And so when I hear that people are trying to kick people off the riverfront or chopping down trees without getting the approval of the majority of the property owners, then I'm kind of like shocked and appalled because I don't know all of it. I don't know a lot about all of the legalities, but I know that's not how it's supposed to work. So I'm very much opposed to the replat. I feel like if you give somebody an inch in taking control and doing things the way they want to do them, then it just exponentially can go from there. So anyway, so thank you for your time.
Thank you, Ms. Madden. Mary Bradley.
My name is Chris Raymond. I appreciate y'all being here.
Just a minute, you're not on the list. Mary Bradley?
Oh, she told me I was ahead of her. I'm so sorry. I can't count. You tell me how.
Didn't look like me. Hi, and good morning, commissioners and your honor. My name is Mary Bradley, and I live at number 1 the Ravine, more commonly called the house with the blue lights if you happen to drive by. But I just want to say I've had the pleasure of listening to my great neighbors talk, and also Bruce, who I always liked very much, but I don't believe that the Plat, as it's presented now and more commonly referred to, I believe, as Lot 24, is going to be at all as they stated. It has been the history, as I've seen it, since I've lived there, and that's been since I bought the house from the caretaker, the true caretaker of the property, and that was Catherine Ainsley. And I bought it based on the fact that we had a community of beauty, the trees, the river, and more than that, a community of people like-minded. And when Daniel Hawkins bought the place, it's not the same. He took down the trees. The deer are no longer in existence. The entrance to the ravine, which I try to keep so pretty because I am the house that you first see when you come in. Since I did not purchase the easement he proposed, he parks in my front to make sure I have no view of the river, but most importantly, people cannot see coming and going. And as you enter and exit the ravine, it's really difficult to see around the corner. And his constant parking there to just irritate me or intimidate me or whatever has caused accidents, not necessarily at that moment, but there have been several, which I have taken many photos of, and it's just not safe. In addition to, I feel like we're in harm's way a lot, and that is because of Mr. Hawkins. He has started fires that the fire department has had to come out to. I personally lost half of my home due to a fireworks incident in 2015, and I'm a little nervous about fires. So we've had 2 major fires since then, since Daniel has moved in, of which he's been told to put, fire or water trucks, at least hoses, and none of that's been done. In addition, I feel just mortified every time I see him because he tells me that I don't matter, that what my wishes is his place, not to go on the river. He actually has driven posts in my front yard of which he wants to put a fence up so I can't see the river. I've seen him drive property values down in order for him to be able to purchase something from a homeowner under duress. It's criminal. It's wrong, and I beg for this court to at least stop him on this, because Daniel's whole philosophy is he'd rather ask for forgiveness than permission. Please stop him, because I would like to have to not come to Commissioner's Court every time we have an issue. I'd like to be able to go to the river and not have to take my restrictions down there when he calls the police. So, thank you for your time. We all appreciate it. Sorry I'm so emotional, but it's my homestead and it's my life. Thank you.
Thank you, Ms. Brady. Now, the last person I have on my list right now, there may be others that want to speak, but is Ray Jeffrey. And you're one of the attorneys?
Yes.
If we have any other lay people that would like to, can we take them first?
Absolutely.
10 seconds.
Yes, sir. Identify yourself.
Yes, sir. My name is Chris Bramer. I own lots 2 and 5 at the Ravine. We actually live in Ann's, Rock's old house. So bought it 20 years ago, and I grew up here in the hill country. Tiny fight never dies. Anyway, I wasn't claiming the fame. What the heck? Guys, things have just kind of changed. I'm vehemently against changing any of the plats. We got those restrictions at signing when we bought the house. Everybody understood we had access, blah, blah, blah. And now all of a sudden everything's kind of changing. And just for that, I'm against replatting. It just opens up a floodgate of everything else that's going to come down the pipe. We okay this, and the next it's the swimming pool in front of my house. So we don't want to play that game. I sure appreciate y'all being here. Thank y'all for consideration.
Thank you.
Thank you, Mr. Bramer.
Hi, I'm Richard Matthew Davenport. Appreciate this time with y'all. This is a situation where it's not your normal thing. It's a case where a guy's come in and bought property just like anyone and thinking, hey, I can make some money here. This is a good deal. There's nothing wrong with that. But when do you make money at the expense of other people to make yourself better and make them worse? Is that a decision we need to make as community citizens? So I'm saying this guy is not a community citizen. He doesn't care about this community. We all either retired here or lived in this area and chose to move into this community because the restrictions were such that nothing else was going to be done. The community wasn't going to be any bigger. It was going to be people that took care of each other. And folks, that's what we've got to do nowadays. We got to look out for each other. We can't wait for the PD to come and do stuff all the time. They have responsibilities, but they want to go home at night too. They don't want to run into a grass fire situation that could turn weird. And all we're trying to do in this is get you to not grant him any permission to replat, because in our restrictions can only be done every 10 years. The next anniversary is 2029. And that's in our restrictions for all of us to honor. He signed the same contract as we did. We all have to get water from the same well. They did away with separate wells years ago. In the idea, I'm assuming, for all the community citizens to get one place to get their well, so that it was taken care of as one unit, rather than each individual having to do it. This was just my thinking, it's what Ann and I can rock on. But all I'm trying to say is, these things that have been done for the community are about to be destroyed if you change this. Because not only is he going to replat, he's going to sell common and try to do things like that. Get his money, get on down the road. I don't think that's what community citizens are supposed to do. Just my opinion. Thanks for your time.
Thank you, Mr. Davenport. Mr. Davenport?
Yes.
Well, would you get Mr. Raymer and both of y'all fill out the application to speak, which is out there at the table?
Oh, I'm sorry, I thought I already was.
And let's get those back, because we'll need records of that.
Okay.
Neither one of you had signed up on the original list, so if you'll sign up and get those to us, I'd appreciate it.
Okay, thank you.
And sir, you are?
I'm in Hawkins. I'm Satan.
Okay. You didn't sign up either?
No, sir, I apologize. This is my first rodeo here at a hearing like this.
Okay, and you're going to have to fill out the same form and get them back to us also?
Yes, sir.
Okay, you may proceed.
Okay. When I first got introduced to the Ravine, a friend of mine had a house there. She had mentioned that she was wanting to sell it. I did a little drive-by. It seemed like a pretty good deal. I took the bylaws and restrictions and everything to my attorney, and he advised me not to buy the house. And I, of course, asked why, and he said the grantor has got way too many rights there. That house in particular is built right on the lot line, right on the property line, where the garage entrance is. And he had advised me that the grantor could build a fence, build a building, build a home right there, and I couldn't even enter into my garage. He said that 7.45 acres is not common area because it's not commonly owned. So I turned the house down. A year or 2 years later, I was driving down 39 in front of Ravine, and I seen a big 4-bay sign that said, Ravine for sale. So I got the restrictions, took them down to my attorney, and I said, what if I could do a deal on this whole thing? He said, it'd be great. He said, you could either build a house on that 7.45 acres, or if the county would allow you, you could replat it and build multiple houses in there. So I ended up buying the Ravine, and then, I don't know, a year or two later, I bought that house I originally looked at. And I didn't know Miss Eichenrod, never met her, and I didn't know Catherine, the lady that bought it from Miss Eichenrod, and Catherine had passed away and left to her son Larry. I didn't even meet Larry. We was negotiating the deal over email and text. Ended up buying it, and so I can't read Miss Eichenrod's mind, but if she wanted true common area, she would have deeded it in each deed. Everybody would own some of it, but nobody would own all of it, so that way it could never be sold unless everybody agreed to sell it, build a pool house or whatever. And I apologize when I bring my attorney up, was just replatting Bruce's deal, but to Bruce's deal, his septic is, like he said, is on my common area. And if he goes to sell his house to somebody that's borrowing money, there's not an underwriter in the state of Texas that will underwrite that because his septic is not on his property. There's three, I didn't realize this when I bought it, I didn't know there was septic issues. There's 3 properties I know that their septic runs on my property. And the Smiths, my understanding, this is just, I just told Mr. Smith this, but A1 Septic had got a call to go and inspect his septic because evidently they were selling the house a couple of years ago. He came back and said, the septic's not on the Smith's property. It's on Mr. Hawkins' property, and they wouldn't underwrite the loan. And let's just play worst case scenario. If this was all undivided interest, that everybody owned part of the common area, And some they still could put their septic system on common ground. It's against the EPA rules, health department rules, and the state's rules. You can't do it because you don't own undivided interest. Everybody owns some of it, nobody owns all of it. And but that's not the case here. I mean, I've got a clear deed to it where I purchased it, and I would like to address the county at a later time about replatting the main part of this, that common area. I mean, to build houses on it and be more tax revenue and really make the place nice. But the water system is another deal. Mary had brought up that there's no fire protection or anything. About 2 or 3 years ago, I had gotten bids to put in these new water lines. It was poorly done when it was installed. And there's septic that's this far away from the water line, open ladder lines. The state of Texas says it has to be 9 feet, the water line has to be 9 feet away from any closed sewer line. We're not even close, so I was going to hire a company just go in there and put new lines in, vaults, I think it was 3 fire hydrants. And I don't remember what the exact bid was, $70,000, $80,000, and everybody had strokes that they didn't want to pay, and I got to pay it all up front, and then I get approximately half of it back from the landowners if they pay, and everybody opposed it. So about I go in there and I fix 10, 12 leaks every single year because this line is rotting and it's getting worse every year. And I don't mind spending the money to do it, but they don't even want to reimburse me for it. And it's just I'm trying to fix all these problems that I have bought into. Basically, is the bottom line. That's all I've got.
Okay. Thank you, Mr. Hawkins. If you would fill out that form.
Yes, sir.
Okay. Mr. Jeffries, you're the next one on the list.
Yes, thank you, Judge Kelly. My name is Ray Jeffrey. I'm a lawyer from over in Bulverde in Comal County, and I can appreciate you all very much. I've spent 15 years in city and county government over in Comal County, and I was mayor of the city of Bulverde. I say it's like being the tallest building in Poteet. So I have over the years gotten familiarity, aside from my normal practice as a civil litigator, with county and city issues. And it's a hard act to follow all these good people. I went out to the Ravine, and it is quaint is the word for it. And it's the hill country from years gone by. It's not the bright, gleaming hill country that is getting developed like crazy today. But what I wanted to focus on and try to answer for you is the legal questions. And I've spent quite a bit of time researching all of the various legal issues that come up with this Ravine subdivision. And I would submit to you that what you just heard from Mr. Hawkins was, first of all, his recitation of what he said that a lawyer told him at some time, and I find it hard to believe that was the advice, and if it was the advice, it was bad legal advice. Because when you're talking about real property issues in Texas, you're talking about well-developed area of the law. None of these issues are of first impression that we're dealing with here. So I just want to jump right into the meat of what the process is here today with regard to a county replat. First of all, there is a critical issue of standing. That is, who can come to you and ask for a replat of a previously, almost 50 years previously, subdivided piece of land. Your subdivision rules and regulations provide in 6.04 very clearly, a person who has subdivided land, a person who has subdivided land that is subject to the subdivision rules and regulations of Kerr County may apply in writing to the Commissioner's Court for permission to revise the subdivision plat. Well, who is a person who has subdivided land? We know who it is. It was Ms. Eichenrod, or Roth, who did the original subdivision and created this little development. Only 12 acres, 23 lots. This question has been clearly addressed one time in the state of Texas. Brunson versus Woolsey. The Fort Worth Court of Appeals held that the exact language in your ordinance means that the only party who may seek a county replat is the developer who filed the original plat. Therefore, neither Mr. Galloway nor Mr. Hawkins, and I don't believe that it's Mr. Hawkins that actually owns what he purchased. He purchased some lots, and he purchased the common area and roadways, subject to the restrictions. I believe from our research that the actual owner is called Patriot Properties LLC. There was a Ravine Development LLC, which looks like it's forfeited its charter. So, standing. That is a very serious issue for y'all. Second, even if we were to assume that the applicants had standing to seek the replat, you have to look at what the Kerr County rules require the applicant to show. Quote, that the plat revision will not interfere with the established rights of any owner of a part of the subdivided land. You've heard from a bunch of owners of the subdivided land. The property owners in the Ravine subdivision object to the replat because they do have established rights that will be interfered with. And it's not before you today, but you've heard there are a lot of other scenarios in which they are being interfered with already. But the only issue before you today is this replat. The reason why this quaint little subdivision works is because Ms. Eichenrod set out restrictions for the 12 acres. If you look at the plat, there's only 3 categories of things. There are individually platted lots, which of course can be bought and sold. There is the common green area, and then there's the roadway. It's basically like mostly a caliche drive at this point. In the restrictions filed close to 50 years ago, Ms. Eichenrod specified, and she declared her desire, quote, to create and carry out a uniform plan for the improvement, development, and sale of the lots in the ravine. It's a comprehensive plan. She stipulated that the, quote, rights, title, and easements reserved in the restrictions, quote, shall be considered a part of the land and construed as being adopted in each and every contract, deed, or other conveyance of said property or any part thereof. That would include every person that's gotten up here and spoken to you, including Mr. Hawkins. He bought whatever he bought subject to these restrictions and covenants. The very first item, I'm just going to point out 2 items in the developer's uniform plan. Items number 1 and items number 2. Item number 1 says the roads, lanes, walks, and common green areas as shown on said map or plat, that's everything outside of the lots, within the metes and bounds of this subdivision, are hereby dedicated to the use of the present and future owners of said lots and their guests. The second stipulation, number 2, made clear that this extended to the waterfront, which is across the street. You know, the subdivision goes down to the street. You have to take your life in your hands, and like I did, run across the street. And then you have this beautiful waterfront right on the Ingram Lake there. All owners of said property shall be afforded access to the lake and may be used by them at their discretion. At the end, the very last provision in the restriction says, "These covenants and restrictions shall run with the land and shall be binding upon Ms. Eichenroth, her successors and assigns, and all persons or parties claiming under her, including Mr. Hawkins or his company." It also provides that there can only be changes made if 2/3 of the owners of the lots vote to make a change. And then finally, any owner in the subdivision may enforce the restrictions against Ms. Eichenroth, her successors, or assigns. And so there are all kinds of issues that y'all can't wrestle with here that might have to be resolved in a district courtroom, but we're just dealing with the issue of the replat. Also significant to the replat is that the next year, Ms. Eichenroth went back and did an amendment. It's just like a one-pager. And one of the pertinent amendment for your consideration is no residential lot as shown on the plat shall be further divided or altered, except lots 5, 22, and 23. None of those are before you today. May be further subdivided by Ms. Eichenroth or by her express written consent, because they were bigger, so they could be divided. 2 or more lots, however, this makes sense, may be combined for a single dwelling. So if you went in and bought 2 lots, nobody's going to complain that you're only putting 1 dwelling on there. So that was the scheme, and it wasn't one of these super fancy ones. It was in 1974, good old-fashioned deed restrictions. Deed restrictions are, under the law, established rights of the Ravine property owners. There's a case, Baywood Estates versus Keolo, if I'm saying that right. The Court of Appeals held, it's common knowledge that parks and open spaces add to the desirability and value of lots and are commonly found in many residential subdivisions. That's what you've been hearing about here. Lots comprising a common area are subject to the restrictive covenants created by the original dedication and restrictions, as well as any amendments to them. You heard that from Ms. Kerr. She said that she was quoting from the message from the attorney and head of the title company, who said, yeah, you can buy this, but you're buying it subject to the restrictions. Just a little bit more. There was a case called the Commissioner's Court of Grayson County versus Albin, and there they discussed exactly what this phrase, established rights of any owner of a part of the subdivided land, means, because that's what if it's going to interfere with the established rights of any of these owners you heard from, then you're duty bound to not grant the replat. And there the court said, generally, other specific rights for a subdivision, such as what use may be made of the property, and a limitation of the size of all lots, and a limitation on the types of buildings, are established by restrictive covenants. These restrictive covenants are sometimes filed along with the plat, either on a separate document or on the plat itself. Or the restrictive covenants can be on the deeds conveying the property in the subdivisions. Well, here you didn't have to go searching for it. There was a separate document, 10 or so pages long, containing all the restrictions that are available to anyone interested in buying a piece of property in this quaint little subdivision. Such restrictive covenants can set out with specificity the plan of development and the rights of the purchasers in relation to all the other lots in the subdivision. One thing that's a little different, and it's kind of partly in the funky character of just the history of this neat little place, is that there is no HOA. So the typical thing is you get some sophisticated developer comes in, they establish all of this stuff. They maintain control over it until they've sold a certain number of the lots. And then if there's common areas, they deed that over to the HOA. Well, there's no requirement in the law that there be an HOA or that there be a deeding over to an HOA. If you just think about it, the granddaddy of all the deed restrictions cases in Texas is out of El Paso from 1914, and there weren't any HOAs around in 1914. So, and that case has been recognized by the Texas Supreme Court as kind of the original authority on this subject. In that case, with the Commissioner's Court of Grayson County, the homeowners lost. And the reason why they lost was there were no deed restrictions. None. And that's what they were pointing out, is you can have deed restrictions. All there was a plat, and the plat had 4 very large properties, like 20 acres each. And the developer sold 3 of those lots. And here these people were out there in clover saying, hey, I've got this beautiful place here, all these 20-acre lots. And then he came along years later and said he was going to turn the 4th one into 18 lots. And of course they were unhappy. Well, the court couldn't do anything for them because there was nothing other than some lot lines on a plat. And it didn't say that they couldn't be changed, that it couldn't be further subdivided. So they were left out in the cold in a very sympathetic case. Of course, what we have here, as we've gone over quite a bit, is that there are restrictions in the ravine. I'd love to just point out to you some language from a great case that deals with these exact subjects. And that's, I think I've given it to the county attorney, but that's this, well, it's the same, no, it's Harris County Flood Control versus Glenbrook Patio Homeowners. And in there, this is just like right on the money. The actual legal ownership of the common areas is irrelevant. The primary issue is whether the developer retained the right to unilaterally amend the plat or create and burden the common areas for the benefit of a different party. This was an interesting case where a developer built a development. He sold all the lots. I think there might have even been an HOA there. And then he said, hey, I'm going to build another development next door. And he tried to impose an easement over to his new development. And they said, look, you cannot do that. This is common area dedicated to the use of the folks that bought within this subdivision. You can't come back later. And what's being done in this case with Mr. Hawkins is pretty extreme. It's clear that what his goal, I'm not a mind reader, but from the outward actions, his goal right now, he's filling in the ravine with rubble, tearing down trees, is if he gets this replat, then what he says is, well, I can replat everything in there and I can build houses on it. And next thing you know, the ravine is going to be the downtown San Antonio is really what it's going to be in terms of density and loss of the character. So, so that's why the homeowners are objecting to this. They have established rights, even if they had even if Mr. Hawkins or Mr. Galloway have the standing, which they don't, to ask for this. It is interfering with the established rights of all these good folks that you've heard from. Thank you, Your Honor.
Thank you, Mr. Jeffrey. Okay, this is still a public meeting. Is there anybody else wishing to be heard?
May I point out one other thing?
Yes.
Just that we've provided the commissioners with a notebook that shows the ravine, it shows the original plat, that's it right there. So
we'll take notice.
Judge Kelly, can I say one more thing?
Mr. Galloway, go ahead.
I know I'm in the Ravine, I'm the poster boy for the devil up there, and that's okay. I did what I did. My septic line, as opposed to some of the others, were granted by this commissioner's court to be where they are. And it's filed a record, and I got the documents put back in the record so that anybody that wants to buy property will see that this is part of the record. I did it for one reason and one reason only. I wanted to do something right, put my septic on my property. And I thought I had that right. I'm the one that filed for the replat. I spent the $3,500 worth of survey fees to get all this thing straightened out and corrected. So I'm the guy that's on the short end of the stick. I wasn't trying to do anything illegal. If I had really wanted to be a jerk about this, I could have taken it under the 10-year adverse possession statute, because I've been cleaning it, maintaining it, and planting trees in there for the past about 20 years. So, you know, I'm just happy to go along with whatever you all decide. But my intentions were honorable. My intentions were not to disengage or take anything from any of the existing homeowners. I was just trying to do a simple thing and put my own septic on my own land, because I know if I go to sell it, it's going to be a simple issue.
Your Honor, that's a new issue. May I just respond to that?
Yes, sir.
He could perhaps have made a claim of adverse possession. His claim, just like a claim under a deed, Mr. Hawkins' deed or whoever actually owns the common areas, he would have taken it subject to the deed restrictions.
I understand. Okay, everyone has appeared publicly and made their appearance. Okay, then the public meeting will be adjourned. Now we will move on to the next agenda item, which is item 1.15. Consider, discuss, and take appropriate action for the court to approve a revision of Plat of the Ravine, Lot 21, and a portion of the common area. Mr. Hastings.
Thank you, owner Bruce Galloway, Lot 21, and Daniel Hawkins, the common area, have a revision of Plat before you. Lot 21 of the Ravine is currently less than 1 acre. This proposal enlarges Lot 21 by adding a portion of the common area. Access is from Icon Road. Don't want to belabor anything that's already been said, but I would like to get it in the record. Part of the exhibits in this agenda bill, Exhibit A has 6 pages. There's a letter from Mr. Galloway. There is a license to operate an on-site sewage facility, page 2 of that Exhibit A. Page 3 is a letter from the former owner of the common area, Catherine Ainsley. Let's see what it's dated. I'm not seeing the date on here, but it's 1993, it looks like. And it says it's okay for you to have your septic system on the common area. It did go to Commissioner's Court. I don't have a copy of a court order in here or the minutes, but read through them. The court said it's okay with us if it's okay with the owner of the common area. There's a well plugging report in here on page 4, because apparently there was a well that was too close to the septic system and needed to be plugged. And Exhibit A, page 5, is a hand drawing of the home, the lot, and where they think that the encroachment is of the septic system. And then page 6 is a survey that shows Lot 21, the proposed expansion of Lot 21, and where they believe the drain field is for that septic that is currently in the common area. The letter, again, that he had was from a previous owner who said it's okay. He didn't get an easement at that time that runs with the land. That's why he's here today. There's a new owner in town, and that new owner maybe doesn't want that septic crossing the line. And I think Mr. Galloway would like to have something on record so that when this lot goes to sell one day, it doesn't pop up as a problem. Exhibit B is straight out of our subdivision regulations. I know that it has been read to you already. 6.04, the revision of plat of existing recorded subdivision states a person who has subdivided land that is subject to the subdivision rules and regulations of Kerr County may apply in writing to the Commissioners Court for permission to revise the subdivision plat filed for record with the county clerk. 6.04C states during a regular term of a Commissioners Court, we can't do it in a special session, so we're doing it today. The court shall adopt an order to permit the revision of the subdivision plat if it is shown to the court that, number one, the revision will not interfere with the established rights of any owner of a part of the subdivided land, or each owner whose rights may be interfered with has agreed to the revision. With that being stated, the county engineer requests the court consider, discuss, and take appropriate action for a revision of plat for the Ravine Lot 21 and a portion of the common area, volume 4, page 16, precinct 4. It's in your hands.
So in summary, the common area is a lot. It's lot, whatever the number is. And that's owned by who?
Daniel Hawkins.
Okay,
Yes, sir.
Mr. Hawkins. Okay, there's no homeowners association, but there are restrictions and covenants that the attorney spoke to. So what takes precedence over all of these concerns? And I'll ask the county attorney that because I've asked her that a long time ago. Who takes precedence? Does the county have the authority to replat something? If it's a homeowners association, that's clear. We probably don't have that authority to revise something that the homeowners association has in documentation. But in this case, that's not the case, okay?
And in this case, I think it's also clear because of the deed restrictions that you have in 1974 and 1975, which are provided here, I think in a couple of different ways that we've given to y'all in the past. That establishes a clear right of all of the property owners within the ravine. And so I think that the court doesn't have the authority to include this revision of plat because of our own regulations and that follow state law, that the revision would necessarily interfere with the established rights of the rest of the owners within the ravine, within that subdivision. And you guys have not gotten a clear agreement from the rest of the property owners within the subdivision. So I think that it provides y'all with guidance that you're unable to.
Okay, the owner of the common area is just another lot in the subdivision, correct?
The owner of the common area, I believe, is an entity, not an individual.
Well, it shows from Welborn Engineering, it shows lot 24, which is called common area.
Well, lot 21 is Mr. Galloway, and then the area on the original plat, which my understanding it has not ever been replatted, has no label for the common area. It doesn't say common area, and then it doesn't say lot 24. What you're looking at is proposed. That's proposed. If you approve it, that will become lot 24. And the only reason it's getting a lot designation is that our regulations require it.
This is a very unique situation. We don't find many situations like the Ravine. And I do agree with the county attorney that approving this plat would infringe on the other property owners to what they have there at the Ravine. So I can't support it.
I think a couple of points. One, and I agree with that. I think, first of all, it would impact property owners and our, I don't know, the way we've always looked at this in the past. Just one person objects, we'll go forward under a different plat, someone, because it does impact the right to the other lot owners. Another thing I wanted to mention is I want to clarify something that Mr. Hawkins said, adding additional lots. This court, unless we change our rules, would not allow any additional lots in the subdivision because it's only 12 acres and you've already got 20 lots on there.
I understand.
So there would be, we couldn't ever, allow additional lots to be put in the subdivision. I also don't think because of the use restrictions, we have authority to do anything to change the lot line. But I do think there's a problem with the septic tanks. There's 3 lots there, and I think that the owners of the subdivision need to get together and figure out how to make an adjustment, which I think what Mr. Galloway's request is reasonable. And I think kind of lot 5, 10, one of them also has a problem. And I recommend they'll try to get together, but this court can't do it.
I see, and I appreciate that. My biggest issue is the question of liability. If somebody breaks their neck out there on the boat ramp or boat dock or whatever, they're not going to sue any of the property owners. They're going to sue the one that owns it. And so I can't remember, it's $3 or $4 million liability insurance. I have to carry the burden for it, plus the taxes aren't much, but the septic issue and the water issue are major concerns of mine because that water line, like I said, runs this far away from lateral line. And I don't believe in the water business. They pay what, $17 a month. It was established in 1974 for water, and they use it. And I lose money every month. It's not much, but I want to have the water business, and I want to get rid of this liability. I mean, I didn't even really consider donating that 300-foot of lake lot to the county. They can open it up for the public. I don't want the burden of the liability anymore.
I agree that there's a lot of issues, but there's several issues that we don't have jurisdiction on.
Yes, exactly.
So I think there's things need to be worked out, and it'd be a whole lot easier to work them out, not in the courthouse, through a lawsuit, but we don't have the authority to do that. We have to follow our subdivision rules are basically straight out of state law, and we don't have authority to make a revision.
Okay, and so the three major lots that have the septic issue, they can't sell to anybody because of the septic issue. And then
that's a civil issue, but it's done, and it needs to be resolved, but we can't do it.
Okay.
I believe lots have been bought and sold in there with those same septic issues.
They have.
Because those would convey, if there's permission for the septic as it stands now for this current lot in question, if it conveyed once, it'll do it again, and with any of the other properties, so that shouldn't be a problem. The established rights seem to be well in place. My question is, how do you sell a common area? If it's a true common area, how does it get bought and sold?
Well, but
And toward what end?
the agenda item is
be able to live on it.
replatting. Just don't go to all the other stuff.
Well,
We've
there's
heard
been a
enough
hell
of
of a
this.
lot of other stuff brought up here today, Commissioner.
But that's not the
I'm
agenda.
not the one bringing it up.
No,
I
we've
didn't
heard-
establish that as part of the discussion here. I'm just saying a question in my mind is, how do you sell something that's supposed to belong to everybody?
That's the thing. If Ms. Ackenrod wanted to prove the common area, she would have gave everybody a piece.
Right, undivided interest.
Yes, sir.
Right.
And she didn't do that. She had an attorney. She was a smart lady.
No, sir, that's not correct. You've heard the Supreme Court say it is irrelevant who is the owner of that common property. It's irrelevant.
Okay.
This whole, I've been a 47-year practicing attorney, and I have tried lawsuits enforcing restrictive covenants backwards and forwards. You need a lawyer. Trust me, you need a lawyer.
All right.
This is a legal question. Our county attorney has spoken. We've listened to the other lawyers speak. You bring a lawyer, and this needs to be in a civil courtroom, not in commissioner's court. I'm absolutely opposed to any approval of any plat like this. It has to be subject to those restrictive covenants.
Yes, sir. It's not in our jurisdiction. It's not our agenda item.
Yes, sir?
But can I still assume that the 1994 Commissioner's Court ruling allowing me to have my septic into the common area is still valid?
Talk to your lawyer.
Well, I think it is.
Well, talk to your lawyer.
Okay?
This is going to be resolved in a court of law, not in commissioner's court.
Civil issue.
County attorney has something to say?
I don't know that our OSSF department would go out there, and Ashley's here, and she may speak to that, but I don't know that she's going out there to issue him a notice of violation for the placement of the septic that was approved by the court, so I think that can give him some comfort.
Not the agenda item.
but I'll answer this question.
Because the only reason I keep saying that, we're going to go on and on and on about all these civil issues. And that's not the agenda item. The agenda item is replat. I think we spent enough time. I mean, I understand everybody's feelings on both sides, but I think Jonathan Letts summarized it very nicely, so.
Is there a motion to approve the plat as requested? There being no motion, it fails. Let's move on to the next agenda item, which will be 1.16. Consider, discuss, and take appropriate action for the court to set a public hearing for 10 a.m. on May 24 for revision of plat for Elm Pass Ranch, number 2, lots 61, 62, 65, 66, 74, and 75. Precinct 2.
The owner is Michael Mayer, proposed total acres 79. This proposal combines and revises 6 lots totaling 79.18 acres into 2 lots. Lot 65R will be 10.34 acres and have frontage on State Mountain Road. Lot 61R will be 68.84 acres and have frontage on State Mountain Road and Elm Pass 2 Road. Portions of State Mountain Road and Francis Drive were abandoned, vacated, and discontinued in 2016 by court order number 35710. The county engineer requests the court set a public hearing for 10 a.m. on May 24th, 2021 for a revision of plat for the Elm Pass Ranch number 2, lots 61, 62, 65, 66, 74, and 75. Volume 3, page 100, precinct 2.
Move for approval.
Motion been made by Commissioner Moser, seconded by Commissioner Baloo to approve the revision of plat for Elm Pass Ranch number 2, lot 61, 62, 65, 66, 74, and 75. Is there any discussion? Those in favor, raise your hand. Unanimous, 5-0. Item 1.17, consider, discuss, and take appropriate action for the court to set a public hearing for 10 a.m. on May 24, 2021 for a revision of plat for Treasure Hills Ranch, tracks 17A, 17B, and 18B, precinct 1.
The owner developers are Margaret and James Salas. Proposed total acres 21.2. Proposed number of lots 2. This proposal revises 3 tracks into 2 tracks. Track 17A will be 7.4 acres. Track 17B 7.3 acres, and track 18B 6.4 acres will be revised into track 17R 18.53 acres and 18R 12.67 acres. Access to both tracks will remain on Treasure Hills Road. County engineer requests the court set a public hearing for 10 a.m. on May 24, 2021 for a revision of plat for Treasure Hills Ranch, track 17A, 17B, and 18B, volume 5, page 397, precinct 1.
Move for approval.
Second.
Motion's been made by Commissioner Baloo, seconded by Commissioner Moser to approve public hearing for the revision of plat for Treasure Hills Ranch, track 17A, 17B, and 18B.
Judge, can we take 5 minutes?
Sure, let's go ahead and take a vote on this.
Oh, I'm sorry.
Those in favor?
Well, I'm on 5 minutes to think about it.
Those in favor, raise your hand. Unanimous, 5-0. Court will take a 5-minute break. Court will come back to order. We'll go to item 1.18 on the agenda. Consider, discuss, and take appropriate action for the court to provide input on a concept plan for proposed 1,040-acre gated residential subdivisions on Ranch Road 480 to be known as Birdie Creek Ranch. Mr. Hastings.
Thank you. The owners are Sutherland Communities. The proposed total acres in the subdivision, 1,040. The proposed number of lots, 179. They could have as many as 208 if they choose to meet our regulations, but they're going with a little bit larger lots in some places. They will be on private wells and septic systems. There is some floodplain out there, and it's a proposed gated subdivision, so these would be private roads. This concept plan proposes subdividing 1,040 acres into 179 lots, with lots ranging in size from 5.01 to 10.3 acres. This would be a gated subdivision with private roads, privately maintained. Primary access would be via a bridge over Birdie Creek adjacent to Ranch to Market 480. Secondary emergency access would be from an existing low water crossing located upstream from the proposed bridge. Although not shown, discussions have included a third point of access in the northern portion of the proposed subdivision, also for times of emergency when both creek crossings are unavailable. The developer is here to answer any of your questions. His engineer is also here. They're standing to my right and behind me. And the purpose of this, per our subdivision regulations, is that if the commissioner of the precinct wishes to bring, or if the county engineer, either one of us, wishes to bring this before the court to gather your comments or input, then we do so. And both the commissioner and myself wanted to bring this before the court and see what your thoughts were, gather any of your comments, your concerns, and your input. This is a rather large subdivision.
Okay. Thank you for coming. Let me talk to the developers. And
yes, sir. Dan Mullins with Sutherland Communities, Ranton River Crossing, Spring Ranch.
Dan, we met with you and Charlie and discussed this, and I think Commissioner Lutz was there also. Let's see, and this is to Charlie and our Commissioner Lutz. A second entrance is not required, but desirable. Is that?
Yes, sir.
That's correct. Okay. And we talked about the possibility of another entrance in case of emergency on the northern part of this. Can you add anything to that?
I've not talked to the two there in the northern part. I've talked to the one to the west, or the one to the west. I've talked to one of their representatives, and then directly to the east, there's another one, and we've talked, but there's nothing.
Okay, so it's a potential, but not to be committed to in here. And also, you mentioned the fact of water availability. Once you discuss, tell us what your plans are there.
Yes, we're doing a water availability study. As we understand, it's not something that you have to do, but it's something that we want to do. Sutherland Communities has been in business for almost 40 years in the textile country. You don't stay in business that long, you're selling people lots that don't have water under. So we're doing a water availability study. We're working with Gene Williams, the groundwater district. We've set where the wells are. They're okay with the spacing, and we've started drilling.
So the study is going to be more than just a study. It's going to be actual drilling a well and measuring data.
Yes,
taking data.
Drilling a well, testing seed.
Right. So it's that type of data establishment.
Yes,
okay. Concept was good. Are we here today for concept approval?
No, sir. We're here for input from the court itself. So if you have no input, that's great. If you do, now's the time to state what your concerns are. And again, as he stated, from our subdivision regulations, because the lot sizes are greater than 5 acres, he does not have to do a water availability study. He wants to do one.
So what approval is needed from the court? Nothing.
It's not for approval,
okay,
just for input.
That's what I want to be on the record for. You can proceed with this because it meets all the restrictions and so forth.
Yes.
So you don't need an approval from the
It should
court.
also be stated, this subdivision as proposed is textbook.
Yeah.
It's a textbook.
Just saying,
Yes,
there's
sir.
no action required from the
There's
court.
no
It's
action
just
required.
for comments.
Yes,
My
sir.
comments are all very, very positive, okay? Looks great.
About how far is it from 173, Highway 173?
About,
Say
probably
Mile and a half.
Okay, all right. I just tried to get a reference.
Yes, sir.
Other question I have is unit 1, unit 2, and it looks like unit 1 crosses the road. So is the plan B to build all the roads up front, or, and if not, it seems like a cul-de-sac would be needed at the end of that road at the completion of phase 1, or during phase unit 1.
We could, I see what you're going to do. Would it be okay if we did some type of temporary turnaround easement there, like a temporary, with actually building the
Yes,
base?
it's something, you can't get their authority to do that, but it's something that needs to be done there, and constructed in a different way.
What, Dan, what are your schedules and plans on this?
We're drilling the wells right now, water availability study, and the plan is to move forward as quickly as we can. We're gonna send in I believe the next step is the preliminary plat, and then final plat PL. So that's the
Okay.
plan.
Okay, when do you anticipate that engineering work to be done? Not to hold you to it, just curious.
Ken, how quickly can you get it done?
Well, the next step is the preliminary plat, which in the next couple of weeks.
Oh, is that right?
I don't know if we need time for the next court, maybe one after that.
Okay.
Kenny might mention your name for the record.
Sorry. Ken Colachny, Matt River Engineering.
Spell your last name, please.
Kolacny. Just like it sounds.
You guys are drilling the wells. Does Headwater got anything to do with it? How sure are you working together?
They were at the meeting, and we sent them where we're drilling the wells. They've also asked us for a site out there for a monitoring well, which we're agreeable to get to.
So there will be a monitoring well?
Yes, sir.
Good point. Okay.
Yes, the groundwater availability is supposed to be done by Wet Rocks. Jim and Kyle Corzine, they're fantastic.
Where are they out of?
They're out of Austin.
Austin.
When would you anticipate everything going, the plat approval, all that kind of, when would you anticipate starting development?
We'd start, plat approval, we would post a bond, record the plat, and start development immediately.
Okay.
This fall, maybe?
If we can get it, I'd like to be going this fall.
Maybe this fall.
Okay, very good. Thank you, guys.
Thank you. Thanks for your time.
Very good. Let's move on to agenda item 1.19. Consider, discuss, and take appropriate action for the court to receive and review the wastewater capacity model prepared by Tetra Tech for the East Kerr County Center Point Wastewater Collection Project, and to consider a policy for future connection of new development to the system. Mr. Berger.
Commissioners, Judge. Thanks for having me today. What you've got in your packet is a breakdown of the capacity of the East Kerr Center Point Wastewater Collection Project. And there are several maps included there that each map has a table on it with a reference to particular locations within that collection system and provides the capacity at that location. So the capacity of the total system is about 1,330 what we call living unit equivalents. A living unit equivalent is approximately equal to the amount of sewage produced by one single family residential home. And so we use living unit equivalents are the same thing as equivalent dwelling units as well. So those would be same, just two different terms that mean the same thing. So those equivalent dwelling units basically can give us an estimate of the number of services that could be applied to that, and assuming that they're equivalent to a single-family residential service. It also gives us a means to equate other types of development to residential development. So sometimes commercial or industrial development would have other flows that would be higher or lower than a single-family residence. So we would refer to that in terms of LUs. That's why we use those units. The capacities given there show that we're currently have planned about 747 LUEs to be fully connected under the project. At this time, that's what we have on the books. That number could go up or down as the project is completed. And that leaves us with about 583 additional LUEs of capacity in the backbone of the system. And so the backbone of the system is basically the sewer line that runs down State Highway 27 and to a lift station at the corner of the highway and Schlader Lane. And that lift station then pumps the wastewater to Comfort, where it flows to the Comfort treatment plant to be treated. And so there's a little more capacity in one of the lines in Comfort. That has actually very little of local. There's very few lots in the area in Comfort using that line that we flow to. So that's an advantage for the project. But that's, so for future expansion of, or additional connections for new development, things like that, to the project, this map can give you some idea of what kind of capacity is available at different locations around the community there. The system was not designed specifically for new development because the Water Development Board will not fund capacity for new development. So the capacity that we have is based upon population growth and that sort of thing. So that's how, you know, we seem to have a lot more extra capacity in one place than we do in another. But that's why. It has to do with how the system was designed and with the size of the pipes that were chosen and that sort of thing. So minimum size pipe is a 6-inch, and if we only have 4 houses on a 6-inch, we've got a lot of excess capacity in that one versus one where we have 50 houses.
So Don, the 700 plus LUEs that you spoke to, that's phase 1, phase 2, and phase 3.
Yes.
So, Judge, you had asked, I remember having a discussion before of looking at capacity at the treatment facility, at various lines, and all throughout the entire system. So what this model does is, it's very, very good, I think. It looks at every point in there, so understanding what's been obligated, okay, in the plans, and also what the capacity is, whether a pump, a line, or whatever, then if additional capacity is to be or requirements are being increased on the system. So it's all in terms of LUEs at each one of these discrete points.
What's the LUE, Tom?
It's the living unit. It's the living unit equivalent is what it stands for, and it's the flow, wastewater flow equivalent to an average single-family residential unit.
Okay, so that's a guesstimate type measurement or what?
Yes and no. There is a range of values that can be used for that number. The TCEQ does have some standards regarding what can be used for calculating that flow.
So ultimately, it's divided use of residential and commercial. It still comes out to a value.
Right, it still comes out to a value. And so if we have a commercial development that produces a certain flow, then we would equate that flow rate to LUEs. And if it was twice what the average residential flow was, we'd say it was 2 LUEs, for example, even though it's just a single connection.
Let me clarify that. This is an overview guide. The actual decision would be that WCID. They know the actual flow at every lift station, and they certainly at the sewer plant. So this says, this number may say 747, we can add a certain number in the spot. They will come up and say, yes, that's accurate, no, it isn't accurate, based on the actual flow coming through the system. And they monitor that daily.
And the system design, just not to get too much in the weeds, has a factor of 4 on top of it, okay, to accommodate if stormwater were to get into the system, all the pumps and the lines and things can take it to that.
Right, for design of a system, since this is a brand new system, it's in a brand new area, the design is based upon some averages that we see over many systems. But every system is a little bit different. And so after the system has been built out and developed, we'll actually be able to figure out what is the actual flow per LUE in the system. But until we have that data to collect, we won't really know, so we're having to use, and that could change this capacity model. And we actually calibrate it to actual flow data.
Does the oversight group, WDIC, do they, CID, do they, they permit it so you can continue to add growth? Or
They have
do
two
that,
things.
right?
They do two things, and we kind of addressed one of those this morning.
Right.
For a large, like new development coming in, both the county and the WCID have to approve it. They're basically approving capacity. They don't care.
Yeah.
They're, design.
But at some point, you're gonna reach where you're a little tight, so they're gonna always approve that.
Yeah. They have to approve that, and if there's, at some point, there will be that no more people can connect it. That's potentially. Or the WCID marks are expanding. A lot of these choke points, I'm telling you, are lift stations.
Right.
A lot of those can have increased pumps put into them, which will make some adjustments, and that's up to the WCID.
Right. So currently the sewer line, the main trunk of the project has that capacity of 1,330 LUEs, but lift station A only has a capacity of 985 LUEs. So to get that full 1,330, the pumps at lift station A would have to be replaced with higher capacity pumps.
In the next agenda item, you're going to hear
that's a relatively
specifically. Yeah.
That's a relatively.
Right.
And I think this in general from documents of the WCID, the water usage, which historically in the WCID, which mostly is in Kendall County, but pretty similar, the historical water usage is below the state average for a lot of these lots. And that's just historical, it's shown over the.
That's just because we have less water here.
Because the Germans and they're real conservative.
But I think Don said it, and the key thing is, this is a model, okay?
Right.
It's analytical.
It gives us
derived,
an idea,
based on capacity.
gives you some information that you can use then to evaluate if somebody brings a new development before the court and they want to connect that development to the system. You have this to kind of give you a guide as to what capacity might be available or what improvements to the system might be needed to address that. Capacity shortfall if there is one. And as more and more people come to the court and say, hey, can I hook onto that system? You're going to get these questions in advance, and that question is going to get asked a lot. Well, is the capacity there? Does the system have capacity? So that's why this model was prepared, was to give you that guidance here. And like I said, it could change in the future. We might want to redo it after the system's been in place for a few years, just to give you better information perhaps. And the values could go up or down depending upon what we find is actually contributed, depending upon people that how much water they currently use. So, but I've worked in with the WCID in the past and I can verify that their water consumption is well below the statewide average. So
very good tool.
I hope that
that's what this is, just a
yes.
tool.
And it's a tool. And to that end, I think it might be prudent for the commissioners at some point in time to discuss, or maybe we could have a workshop to talk about a specific policy for reconnection that would provide the court with guidance on, you know, who connects and what the requirements are for those that connect. In addition to your subdivision regulations, you might want to have some requirements that just specify who pays for what when they connect, and who does the design, who does the construction, and make sure that there is some oversight on all of that to ensure that the project itself is not compromised by new connections being added to the project, so that the goals of the project are not compromised.
Good point.
So.
Okay. Good job, Don. Charlie?
So there's no action to be taken on this item?
No.
Just information?
Just
to receive it. Yeah.
Anything else?
The item was listed as, and if you wanted to establish a policy at this time, you could. So if there's something, if you're feeling like you'd like to make a statement on a policy on how you want to handle these future connections and bringing back the model and coming to the court saying this is how much it's taking, yea or nay, you can do that now.
That's kind of,
I think
it'll be taken care of.
Yeah, I think to do that, to have a policy is good, because I envision, not too long ago, like 2 or 3 competing things that would saturate the system. How do we make a decision on which one of the 2 or 3? It would be good to have a policy like that. I don't think we can do that today. I think there's a lot of discussion that goes into that.
Ultimately, it's going to be based on usage, right, regardless of what's out there. So.
Yeah, well, if it's somebody, the system is designed, if it's proposed to be expanded, and just hypothetically, say 2 different entities propose to expand, okay, and take all the capability of the system, okay? So how would the court make a decision along the WCID which of these 2 we would approve? So that would be the policy thing that doesn't exist, and I think it's worth, perhaps it's appropriate, may not ever get to that point. We may have the system built before we ever had any competing things like that.
I think, you know, I think policy good to have. I think the 2 things for number one, once we get into that, WCID has to have a huge part, because they end up owning the system after once the debt's paid off.
Sure.
And I can envision it at some point, they may want to go in and, you know, change out a lift station on their own or issue debt to upgrade the whole line. I mean, it'll be an economic decision, I think, for the WCID when they take ownership.
So that's a taxing entity.
Yes.
So ultimately, though, they could put the kibosh on something anyway.
They can. I mean, they're ultimately the ones that have to process it. They own 100% facility comfort, and they're subject to TCQ regulations. So they're the ones that control the capacity. Ultimately.
So then it would make sense in my mind to see if they have recommendations for whatever our policy is.
Oh yeah, that'd be part of it. Okay.
We
just use what they say.
Pretty regularly. Probably a lot more than I do. But,
yeah. You work with them, Don.
Yes. They do have policies, yes, for their system, and similar to subdivision regulations. But they do have detailed information in those policies regarding design of sewer systems and the like. So yes, your policy could mirror what they do.
And one of the things that is odd, well, they have a very unusual enabling legislation that originally formed. Every property that's hooked up to the system in Kerr County can become part of the WCID, or they can opt out. And if they opt in, then they vote, they're taxed, and that, you know, they would vote on, you know, a debt issue or something like that, and then they would help vote who the membership is. And so, but the way they're set up, you don't have to do that. So they have a whole lot, and they don't have to be contiguous or adjacent, so they can opt.
If they have an interlocal agreement, or how does that work? Do they have just state law saying that
they're under their enabling legislation, they can expand anywhere in Kendall and Kerr County under their legislation. Now, obviously, it doesn't make sense for them to go to Ingram, because it's got to be processed. You know? So,
makes sense.
But And the other thing I was going to mention that if when we get the policy, that policy probably needs to go through the Water Development Board because the initial ILA was approved by the Water Development Board. And well, the change we made today, which is pretty minor, I don't think we need to get there. I think we need to send them a copy of it, Charles, just so they have it, updated files. But we start, a policy probably would need to go through them for approval, I think.
I'm hearing workshops.
Yeah.
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 I'm always here at workshops.
Well, there's a lot of moving parts.
It's a lot, it's complicated.
A lot of players.
Yeah, nothing we do today.
That's right.
Thank you.
Thank you. Next item on the agenda is 1.20, consider, discuss, and take appropriate action on the request from Centerpoint Village to connect to the East Kerr County Wastewater Project. Mr. Hastings.
The proposed Centerpoint Village, also known as Eden Farms, consists of 149.5 acres divided into approximately 166 single-family residential lots and approximately 127 RV lots. I'm looking to my left and right to see if those numbers are still right for the developer. Okay. It's a combined weighted total of approximately 230 living unit equivalents, LUEs. The development proposes to connect to the East Kerr County Centerpoint wastewater system. In order to handle the Centerpoint Village subdivision, portions of the existing sewer system on the south side of State Highway 27 that have already been constructed, they're already in the ground, will need to be upgraded from 6-inch to 8-inch diameter sewer mains, and several pumps will need to be upgraded as well. Several sewer mains not yet constructed under Highway 27 and on the north side of Highway 27 will also need to be upgraded from 6 to 8-inch diameter as follows. Upgrade 6-inch to 8-inch sewer in Phase 1. That would be done by the developer. Crossing Street. That's all in Crossing Street. That would be handled under this interlocal agreement we have with WCID as additional construction. The document that you all approved earlier today. Upgrade pumps in Phase 1, that would also be done by the developer. That's in lift stations N, F, and E. There's some bottlenecks in each one of those lift stations for the pumps. Okay. Upgrade 6-inch to 8-inch sewer in Phase 2, not yet constructed. That would be done, paid for by the developer through the county. Tallwood Drive, Boxwood Drive, State Highway 27, and we could handle that through change order. The engineer's estimated probable cost of construction for upgrades to Phase 1, already constructed, which is already constructed and currently in use, is $428,000 and could be handled through sewer system permitting, where the developer's engineer creates the construction plans, the bid, he bids the project, he hires the contractor, and it's all under the oversight of the county engineer and the Kerr County Water Control Improvement District Number 1. The engineer's estimated probable cost of construction for upgrades to Phase 2, which is under contract but not under construction yet, is $25,000 and could be handled through a funding agreement where the developer pays for the change orders with the county's contractor. The number of wastewater living unit equivalents required for Centerpoint Village could change contingent upon the required availability study, water availability study, and final engineering report as outlined in Kerr County's model subdivision regulations. For example, they do their water availability study and they find out there's not as much water as they thought to handle. All these numbers, the 166 single family and the 127, those could change. We don't know. Therefore, county approval for the developer to proceed as outlined above should be contingent upon the submittal and approval of the said water availability study. And I've got a little map in there that shows these upgrades. This has been a work in progress. I think this all started back in about January. There's been public meetings, there's been workshops. We've had several court meetings on it. And I have to admit, at the time that this came forward, we just barely finished construction of Phase 1. We're trying to get a contract going with Phase 2 and 3. And we really weren't in the best position to, on the first day, answer the questions of what will it take. So the development of the wastewater capacity model, which you just saw for the first time today, helped to answer a lot of these. We didn't know 3 weeks ago that pumps in those lift stations might need to be upgraded. We just found that out.
And this was the forcing function to get the model developed.
Yes. So we're in a real good position moving forward to answer these type of questions for developers that want to come in and attach to the system.
On this project, there's already been installation, or this is just an upgrade? This is nothing to install?
This is all new system. This is
proposal.
This is
Nothing to do with your.
Right.
You haven't invested.
This is a design change for phase 2.
Which changes their specs.
Changes the contractor's requirements, okay, the design. That system hadn't been installed. The system that's already installed means digging it up, changing the line, and changing 3 pumps. So that's something that exists. Okay, and that would be the, what was it, Charlie, total of $450-some-thousand to do that, okay?
Yes,
and what Charlie said is that would be done by the developer using their contractor, but approved by county engineer.
So it's not something they installed, but it is installed.
Part of it is installed.
The parts that are installed will be upgraded.
Right.
They would hire a contractor to come in, dig it up, change it out.
Right.
Yes.
Right.
And then the other part hasn't been constructed yet. They would write us a check for the change order.
Sufficiently less money involved. Yeah, a lot.
A lot less if you don't have to dig it back up. Do it once. Yes, sir. So this is an action item. I don't know, would you like Brandon to
Yeah,
come up?
I think Brandon,
Give us
ask
an
Brandon to be
update.
here to give us an update
Very good.
on the Center Point Village development plans, schedules, etc.
Sorry, I got to refer some notes. Good morning. I did want to provide an update since our concept approval in February. At the time, we were estimating our engineers to be done and completed with all their studies, engineering studies, topography, to have plans submitted to the county for review and permitting by May, June timeframe. It's looking like May is going to be the month we're going to be able to submit most of this for review and permitting. Those hand in hand, we've hired a local attorney here in town to finish and construct our condominium documents. At that time, we'll be submitting those as well simultaneously with our engineering plans for permitting as well as the condominium documents to the, I guess, the court is the process. But so currently our process is May. Obviously, we have an interest in this decision on the sewer upgrade because we're obviously going to be footing the bill for it. That is in May. Since then, I know some of the questions that we've done since February. TxDOT, we've huddled ahead with TxDOT, submitted our concept plan. We've hired a traffic and engineering study to be able to produce the documents that TxDOT required. We received a green light from them for moving forward. We will have to modify our driveway slightly, but they were comfortable with what's in place, what we are trying to do. So TxDOT, we were able to check that box. One of the big questions that we had to, the box we had to check was getting some easements to be able to connect to water and sewer, and we were able to secure those. Those have been recorded. Water availability, we hired an engineering company to do that. We hired them back in March, and they're in the process of getting the water availability report back to go so we can submit that with our plans, which obviously is contingent on anything moving forward there is the water availability report. We've also had several meetings with area businesses. We were put in contact with the Economic Development Board and talked with them extensively about what we're bringing to the area, and they have put us in contact with several businesses that are existing in the area. We have had meetings with James Avery, All Plastics, State Hospital, and we have several others on this book to have over the next month just to discuss their employees' needs from
from anywhere from placing new employees to current employees being bused from San Antonio area to here, or just any needs that they see for their employees. So that we're trying to answer those questions too, based off of, one of the reasons we're here is to try to provide workforce housing, and we've received some really good feedback from them, a lot of interest. We're as simple as when can they buy them, because they have a big need for their businesses, and there are companies that we're on hold with visiting with until some further announcements. When they actually will dial in how many employees they will be bringing into the area. But it's been a good rapport, well received with the businesses that we've discussed with at this point. So we're looking forward to May, June timeframe when we can hopefully be permanent and start moving dirt around.
So assuming that occurs, let me back up one other question. With TxDOT, are they requiring anything, changes in Highway 27 itself, acceleration lanes, turning lanes, anything like that?
No, sir.
Okay. And then if all this occurs in the May timeframe, what are your plans scheduled for beginning constructions and when sales of property
We are
will
trying
begin?
to be teed up to be start construction as soon as we get permits. So that means probably the June timeframe is when we probably want to begin.
Okay. And then with that, when would you anticipate first units?
First unit
built?
for houses for sale. Our goal is, until we find something else that may not allow it to happen, is to have houses on the ground by the end of the year.
Okay.
That's our goal.
Okay. All right. Sound like good progress.
Brandon, I'm not familiar with all of the different engineers that do water availability studies. Who is it that you hire?
Unit engineering.
Good, okay.
And so with that, one other schedule thing, when would you drill the wells?
I tried to get that update today on the way I was driving into town, and I wasn't able to get an answer, but it's in the process. I don't know exactly when we'll have our permit to do it, but it's in the process.
But you'd expect
Yeah.
sometime.
And they know our timeframe when we're trying to submit our plans.
Okay. So would you anticipate having that information when you come back in the May timeframe then?
Yes,
Got to have the
sir.
water availability as part of that.
Yes, sir.
Right, okay.
Obviously, that's a big component for us to move
Sure.
to.
Okay. All right.
Any other questions I could possibly answer that, Mike, is there anything else that I missed that we've done?
No, just,
Yeah. Anything else?
I think that's it. Sound like that's
We're moving forward.
5 items. Okay.
Again, this is an action item. They're wanting permission to tie onto the sewer system.
So
That's
the motion is to enter into agreement with Eden Farms to change the design of Phase 2 in the wastewater system and to proceed with modifications to the system as delineated by county engineers for Phase 1, which includes replacing the line on Crossing Street, upgrades, lift station pumps on lift station N, E, and F.
That's
Okay?
correct.
And that for that, Eden Farms will be responsible for that, those changes and approval of any work to be done by the county engineer.
Yes.
And WCID is part of the agreement.
Did you mention also the upgrade of the 6 to 8 in Phase 2?
Yeah, well, I did
think you
mention
did
it.
on
Yeah.
Tallwood Drive, Boxwood Drive, and Highway 27.
Specifically in Phase 2,
Yes.
change the line from 6-inch to 8-inch.
Yes, sir.
Right. Okay, so with that, I move for approval. I'll make that motion.
I agree, but I think that's, my problem is that we don't have anything to approve. There has to be a development agreement. And I think that we can approve the concept, but there has to be an actual agreement. And I understand Brandon's point. He needs us
Say yes, right.
We can't approve it until we get plans that are approved by WCID and Ken and Charlie and that would include both additional construction and change order. And all of that is addressed in the ILA, so I'm trying to figure out.
Don't you just turn in a change order?
Well, but there's a whole lot of.
There's big ones or short ones.
And it's addressed in the ILA, so a lot of the process of how that's done.
Right.
What I'm just saying is that I'm not sure what we do today. I'm going to let Ken drink a little bit.
Well, I guess what we could do
I
is
don't think we do anything.
move forward with the development plan, then to be brought back to the court to be approved.
We could approve a development plan to tie into the system, subject to.
Well, that's how, what I interpreted, it was going to be subject to our plans being permitted and our availability support.
So I think it's a broad one, you know.
Is it still like approving a concept plan?
Well, it's like approving to tie into whatever.
I think what we're doing is making a motion to approve Eden Farms Center Point Village to tie in to the East Kerr Center Point wastewater system, okay? Contingent on their permitting approval, period. And proceed with developing the development plan. Can probably be worded more simply than that, but.
That's it, because it's a permit. I'll second that motion, because I think that's what we're doing. We're approving them subject to water availability, which is the permit issue, and the developing plans.
Sound good to you, Charlie?
Yes, sir.
Somebody restate.
I'd like to know if Brandon's comfortable with that. Does that get you where you need to be? Make sure there weren't anything else in weeds that we were.
That was the main thing. We want to make sure that you're comfortable moving forward.
Yeah, because I understand it's all contingent of us providing our engineering documents.
Yes.
But if for some reason there was a reason that you couldn't allow us to connect.
And then need to know today.
Yep.
So the motion is to, restate it again, is to approve Eden Farms / Center Point Village to move forward with developing the plans to tie into the East Kerr County Center Point wastewater system. And that's the motion. And that will include all the engineering, the contractual stuff and everything else to be approved by the county engineer and in accordance with the interlocal agreement with WCID. I said stop at that motion. I kept the motion simple.
You say it again.
No.
Does that change?
I'll let the reporter said when I said stop at the motion right there. Can you repeat that for me? I'll try it again. Make a motion to approve Eden Farms, Center Point Village, moving forward with developing the plans to tie in to the Center Point, East Kerr County Center Point wastewater system. And all that is to be contingent on permits being approved by this court for the development.
A whole lot of details swept under the rug on this one.
Yeah, it sounds like to me that it's a restating of what was already part of the project. When you proceed with the project, you have all of it just
I think it changed when they started figuring out data on what needed to be upgraded and bumps needed to be changed. So then there became a bill that needed to be paid and who was paying it. And then if we're going to be paying those bills, I want to make sure we have access to connect to those pipes.
That's the whole thing, Charlie. Just, are they going to get to connect to the system if he pays for all the upgrades?
Was that stated in the motion though by him?
Yes.
Okay. See, I would have just said go in peace.
When I said
That would have been the end of it.
when you say development plans, that means the cost and how to do it and all that.
Okay.
He's
So
going
this is
to
all
come
site.
back forward with that. Come back
This is all
with
site
that.
costs and what we had on our concept usually was everything on site. So now we're discussing off site, your systems, and we just want to make sure we're allowed to upgrade them.
So what's the order going to say?
To me, to me, it's authorized, Center Point Village to connect to the, East Kerr wastewater system, subject to water availability and, construction documents. To me, that's it. That's
Well, and you use the term development plan, and I think that's good, where how they're going to bring their contractor in, going to be approved by the county engineer. That's the reason I use development plan. Okay.
That one's clear.
Jonathan?
What Jonathan just said was clear and sounds more like the intent of what is happening today.
I agree.
I'll go along with anything that'll let us move forward.
So you want to modify your motion to state what Jonathan just said, to authorize connection to the system subject to water availability and development plans?
Well, there's more than water availability. They're permitting to get, they have to have a plat, okay, which they haven't provided, right? They have to have water availability. They got a lot of other permits that have to be approved. That's the reason I didn't say just water availability. That's a key part of it, though.
I thought their plat was in the concept plan.
Not formally. No, that was just a concept. That was.
It was discussed that they had to provide them. Yes, sir. But it's not a part of the concept plan.
You know,
Restate yours, Jonathan, except instead of saying water availability, just say permitting approval by the court and development plan.
Can you do it again the same way?
So I'll just have a good suggestion, subject to the plating requirements instead of saying water availability.
And I'm gonna time you.
Make a motion to authorize Center Point Village to connect to the Center Point East Kerr wastewater system, subject to,
What?
So, permitting.
Because that's where the devil is, in the
Yeah.
details.
Subject to-
And we're not getting any detail.
subject to, I think, the water availability study, preparation of construction documents, and other development issues that need to be approved by this court.
That's good.
Wow.
Second.
In under 30 seconds.
Second.
Which means that subdivision rules, water availability, and they have to develop construction plans.
And this again just lets them move forward knowing that they're gonna be able to do that, if they meet all the other requirements. Okay, motion and a second.
Well, who's got the motion and who's got the second?
Jonathan had the motion, I had the second.
So the first motion's withdrawn.
Yes.
Yes,
Now we're to the last motion.
Yes.
correct.
And you're seconding that motion.
Yes, sir.
Does everybody understand what we're voting on?
Yes.
Those in favor, raise your hand. Those opposed, raise your hand. Those abstaining, raise your hand. So, 3, 1, and 1. God be with us.
Okay.
Next item on the agenda is 1.21. Update on proposed Comfort RV Park located at Herman Sons Road and State Highway 27 and their proposed connection to the East Kerr County wastewater system.
Same song, second verse.
Yes.
This is no action.
This one's easier. The proposed Comfort RV Park located at Herman Sons Road and State Highway 27 consists of 201 RV units on approximately 75 acres. The 201 RV units represent 100.5 sewer living unit equivalents, LUEs, and is proposed to be connected to the East Kerr County wastewater system at a location past the last pump station. Therefore, it will have no effect on the sewer system capacity, subject to the engineering design described herein. So there is a caveat. Comfort RV's engineering consultant, Wellborn Engineering, has coordinated the proposed sewer connection with the Kendall County Water Control Improvement District Number 1, KCWCID, they're the operator of the sewer system. Tetra Tech Engineering, that's the county's wastewater engineer, and the county engineer, that's me. Connection to the system is subject to the developer installing communication and control devices between pump station A, the Comfort RV pump station, and the Kerr County WCID number 1 wastewater treatment plant. The communication and control devices would ensure that pump station A, that's our pump, our big pump, has pumping priority in the event that both pump stations need to pump at the same time. And it would allow KCWCID number 1 to monitor and control the pumping stations remotely. Hence, capacity in the East Kerr County wastewater system is preserved. In addition to this, the Comfort RV pumping station will include additional wastewater storage capabilities in the event that both pump stations need to activate simultaneously, because it still could happen, thus allowing for pump station A to have priority. Wellborn Engineering will submit their design to Tetra Tech Engineering, the KCWCID number 1, and Kerr County Engineer for review, comment, and approval. Following approval of the design, the developer will hire a contractor for installation, inspections, construction oversight, and final acceptance will be performed jointly by Wellborn Engineering, KCWCID, and the Kerr County Engineer, similar to public infrastructure for subdivision. No action is necessary from the court. This is an informational item only. Please see a sketch of the wastewater system in your packet. Are there any questions?
What is the capacity of the system from the RV park in case both pumps can't function at the same time?
Yeah, Don here, you want to answer that?
I don't know what the capacity.
How many LUE days will it be able to accommodate?
We're looking at trying to do like 6 hour backflow.
6 hour? So 6 hours of the LUEs that are proposed. Okay, all right. And that's to be approved by WCID and the county engineers being adequate?
Yes.
Okay, all right.
This will not require any information, any planning.
Right.
There's no planning done by the county.
Right.
Okay, any other questions for Mr. Hastings? Thank you, Charlie.
Thank you.
Let's move on to item 1.30, consider, discuss, and take appropriate action to amend the Hill Country Regional Public Defender's Office Oversight Board membership and policies, which was approved October 26, 2020, Court Order number 38409, to delete the requirement to post agendas for the Oversight Board Committee pursuant to the Open Meetings Act. This goes into the lessons learned category. We're getting ready to have our first quarterly board meeting for the Oversight Board. I think it's this Thursday. And what we found is that we put in the policies that we make this all subject to the Open Meetings Act, and really what it is just a department of Kerr County. It's not the elected officials, even though it's a 5-county board. And trying to coordinate all of that for the postings and everything became quite cumbersome. We rescheduled it. I think we're on our third date now, trying to do this. And so I was bringing to this court to let you know that as far as the PDO goes, the Oversight Board, we don't see where that's necessary to post those agendas and have them necessarily open to the public, because one of the things that we learned, especially in light of this salary dispute over the new DA, assistant DA, we have to remember that the DA's office is the natural adversary of the defender's office. And we're not sure you want to show the playbooks back and forth to one another. The DA's offices are not open to the defense to go in and find out what they're paying or what they're doing. And quite frankly, John Bull and Elizabeth Ferry, who are running the PDO, were a little concerned that they'd like a little bit more privacy in those meetings to report to their oversight.
Is that a unique situation, Joe?
Very.
Yeah. So I can't think of any other departments that can't share information, or that it would be detrimental.
Attorneys.
Yeah, attorneys.
Mine, the DAs.
Yeah. It's an attorney-client issue, is what it is.
And so once because you have the same people go through your court as district court.
Sometimes, yes.
Sometimes. So.
And he doesn't want to share, John isn't going to want to share the same information with me either. It's the same issue. It's DAs and county attorney. If he's got something that he'd like to talk to that oversight committee about that's not really my business.
So this doesn't set precedent.
No. And one of the things that we're learning, talking about lessons learned, if this is the PDO and this is Kerr County, they are a department of Kerr County, and somewhere in between this area in here is that oversight board. And so the oversight board doesn't really tell the PDO what to do ultimately. This court tells that department head what happens in that department. But we've got this curious relationship. It's a very unique relationship. And we have the oversight board mainly because we've got 5 counties involved, and these other counties need to know what's going on. And we want their input before we come in and unilaterally tell them what they're going to have to do.
And it's a statutory requirement for having an office like that. You have to have that oversight board. It's required.
With reps from each
Right.
county.
There's a list in there of who may be included as members of that board.
And it's also, under the statute, not a requirement to be open meetings. Right. Which is important. I make a motion that we modify the oversight board membership and policies document by removing the requirement for those meetings to be subject to the Open Meetings Act.
Second.
Motion's been made by Commissioner Letts and seconded by Commissioner Harris to delete the requirement that the meetings for the Public Defender's Office be subject to the Open Meetings Act. Any more discussion? Those in favor, raise your hand. Unanimous 5-0. Item 1.31, consider, discuss, and take appropriate action on organization of payroll function.
I'll start on this one. There was a discussion a while back, brought in by the treasurer, that the treasurer thought that she could handle the payroll function. There's some changes in the HR office due to a vacancy. The question is whether we wanted to look at changing the payroll function. My recommendation is that we don't, but it was on the agenda because we just, a lot of discussions happened since this was put on the agenda. I visited with the judge a little bit last week, but we haven't talked about it since, so he may have a different opinion. I don't know. I'm not sure what his.
No, all these are discussions that are taking place. We've been visiting with HR and the treasurer about these issues. And really the court needs to know that these discussions are taking place. I don't know of any recommendations at this point. There are pros and cons both ways, but we put it on the agenda to make sure that it was disclosed to the full court. And same thing for the next agenda item.
Right. What are some of the pros and cons? From your
I can go over some of them.
Okay.
I'll tell you, a big con in my mind is that, and I'm going off a long time ago, payroll function is critical. And along with that goes with reporting to the IRS and Social Security and all that. And we got in a big pickle in this county because that was not being handled properly by a former elected official. And at that point, this court moved it out of that so we had direct control over that, because we can't do anything. We can't terminate an elected official, but we can make a change in the HR department if this issue is ever to come again. And that's, for me, is the biggest reason.
Well, that issue's not going to come up. We're not talking about doing it. But we do have control over departments that we don't have over elected offices.
Right.
Sure.
So the other, I think, a pro is that it's, and this is also a con, it keeps a separation of money, of checks and all that. It's the payroll checks and a little bit of the checks and the balance. But that's also probably a con, possibly, that maybe it's more efficient to put it all into one office.
Isn't that just a division of accounts, or is it general fund stuff?
It's a lot of, Jen can probably answer this a lot more than I can, but there's a lot of, when you get into HR payroll stuff, there's a whole lot of stuff that has to go through HR, like changing steps and grades and all that. So you're almost dividing that work into two departments right now, it's in one department. And that can be more cumbersome.
And the confidentiality aspect of it, most of the changes that happen in payroll are due to these things, the unpaid leave, promotions, transfers, military leave, FMLA, workers' comp, and those are all confidential that we would, I would rather not share documents within the department.
And I want to make it clear in my comments, our current treasurer does a fantastic job. I have no concern about her abilities.
This was past tense.
Sure, that's understandable.
So anyway, I don't see a reason to make a change. I think it's working right now.
So there's no action on this?
You can make a motion if you want.
No, it sounds like it's information.
I don't think there's any recommended action at this point.
Okay.
All of this came up when we learned of the changes in the department and thinking, what are our options?
Sure.
So I'll move on to the last item on the consideration agenda, which is 1.32, consider, discuss, and take appropriate action to step and grade for Human Resources Department employees.
And I'll start on this one too. There is a vacancy in that office, and we just last week looked at it. I couldn't remember some changes that were made several years ago with that position. I've since, and the question was whether that should be, or historically has been a 20 position, level grade 20. It has been, so I would recommend that it stay where it is. Not really a change it and go back from to a 20.1.
So that's a motion?
No.
Not really, it's our policy.
Okay.
It's really more information.
It's more information.
We didn't know where we stood when the change took place, or was announced. We put these on the agenda for us to be able to make everybody aware and at least know that these are possibilities.
Sure.
But the exiting employee from that department is a grade 20, and historically that assistant position has been a grade 20. So that's not alarming.
I have some new information. It's just been whispered into my ear.
Okay.
Breaking news.
Breaking news. The salary study recommends this be a level 19.
19?
So I'll make a motion that this position be changed to a grade 19 position.
Okay, well, then I'll say, yeah, there you go.
Okay, the motion's been made by Commissioner Letts and seconded by Commissioner Harris to make the assistant HR director a grade 19 position. Is there any discussion? And just so that you know, one of the things that we were looking at is when you consider not only the grade but the steps, we were looking at a very high salary, and we were just looking at what are our options at this point. And if the salary study is recommending a 19, that makes it a little bit easier for us to accommodate.
Okay.
So, those in favor, raise your hand. Unanimous, 5-0.
Was that for a particular position you said, or?
Assistant HR director.
Yes.
Or an HR generalist?
HR generals. Okay. Believe it or not, it's almost 1 o'clock and we've got the approval agenda. 2.1, pay the bills.
Invoices for today's approval amount to $698,815.88.
Move for approval.
Second.
Pay the bills.
Thank you.
Okay. Motion's been made by Commissioner Moser. Who's seconded? Seconded by Commissioner Baloo. Those in favor of paying the bills as presented, raise your hand. Unanimous, 5-0. Budget amendments?
We have 6 today. 5 of them are line item transfers within our department. Constable 4, Sheriff, Parks Maintenance, 216th and 198th District Courts, and also got her certifying new revenue for the Child Abuse Prevention Fund.
Move for approval.
Second.
Okay. Motion been made by Commissioner Letts, seconded by Commissioner Baloo to approve the budget amendments as proposed. Any discussion? Those in favor, raise your hand. Unanimous, 5-0. Late bills?
Yes, we had one late bill, $23,726.93.
This is so small, I can't read it. What is this?
That's why I have the big page. $23,726.93.
I move for approval.
Several things.
It was just one?
Purdue Brandon.
That's what I'm asking. I couldn't read it.
Okay, we've got a motion from Commissioner Harris. Is there a second?
Second.
Seconded by Commissioner Letts to approve the late bills as presented. Any discussion? Those in favor, raise your hand. Unanimous, 5-0. Auditor reports.
Yes, internal audits were performed and reports submitted for the offices of Bob Reeves, Tax Assessor Collector, Tracy Sullivan, County Treasurer, and J.R. Hoyne, Justice of the Peace, Precinct 2. I'm asking that you accept the reports.
So move.
Motion by Commissioner Moser, seconded by Commissioner Blue to approve the auditor's reports as presented. Any discussion? Those in favor, raise your hand. Unanimous, 5-0. 2.5, accept monthly reports.
Yes, for March 2021, payroll report, County Treasurer Tracy Sullivan, Animal Control Services Director Reagan Gibbons, Environmental Health OSSF Director Ashley Batters, Indigent Services HR Director Jennifer Doss, Constable Monthly Report, Constable 1 Tommy Rodriguez, Constable 2 Kyle Snyder, Constable 3 Ken Wilkie, Constable 4 Brad Ryder. Fines, judgments, and juries fees collected, JP1 Mitzi French, JP2 J.R. Hone, JP3 Kathy Mitchell, District Clerk Dawn Lance, County Clerk Jackie J.D. Dowdy, to include annual statistics summary. I move for approval.
Second.
Motion's been made by Commissioner Harris, seconded by Commissioner Letts to approve the court orders as presented. The monthly reports as presented, sorry. Any discussion? Those in favor, raise your hand. 5-0. 2.6, court orders.
Yes, we have the court orders from our Monday, March 22nd meeting, numbers 38624 through 38648. Did have a slight change on court order 38624. It read, approve the proclamation sustaining that March 21 is the 19th annual March for Meals Month and authorize candidates to sign the same. I think we should delete the word sustaining. Counter change. With that, I'll make a motion to approve.
Second.
Motion's been made by Commissioner Letts, seconded by Commissioner Harris to approve the court orders as presented with that one revision. Any discussion? Those in favor, raise your hand. Unanimous, 5-0. Information agenda, status reports from department heads. 3.2, status reports from elected officials. 3.3, status reports from liaison commissioners.
Just a quick one I think most support knows, but the Kerr County Fair has announced that they will not be doing a fair this year. They're evaluating the future of the fair. They've asked for some public input on that. And at the same time, I've had some discussions with Spectra about how they may help. So that's all working right now, nothing to be done. Everyone's kind of evaluating how to go forward.
Okay. Any other liaison commissioner reports?
Yes. In visiting with Shane and maintenance, we walked around the outside. In fact, I was going to get with Mr. Letts on some things. But out here, the other side over here, by the generator, that area, that big hedge that was there, the freeze knocked it out. All that stuff is dead, so we're going to have to do some improving out there, and we're kind of bouncing around some ideas. So any of the rest of you commissioners have any ideas? We thought about maybe just putting some crushed granite in there to where it doesn't have to be mowed or weed eated and stuff like that once we remove all that, but we're open for suggestions.
How about we just paint the generator camo? Yeah, it'll look like we have something going on with it.
So, anyway, that's it.
Any others? Okay, then that will close out our regular meeting. We're going to go into executive session to consider.
Judge, the item that I had, I think that can be deferred. The
Human resources?
Yeah.
That's 4.2A.
Right. I think that can be handled at a later date.
And so then the only other thing we would go into executive session for would be on economic development on 4.3A, discussion regarding financial information pertaining to Precinct 2 business prospects.
And now just take a few minutes, but I do want to be executive session.
Okay, then we will adjourn from public session and go into executive session. We'll take about 5
short
minutes.
break.
5 minutes. I don't believe there's any action items to be taken, so we are adjourned.